Sir, I hope I'm audible.
Yes, you are on.
Good afternoon to one and all. I'm privileged to welcome all of you to the intra competition virtual education program 81. First of all, we welcome our principal, Dr. K. Raghunathan sir, who is leading us. Next, I like the coordinator of the SNC movement, Babu sir, as well as next, a warm and hearty welcome to MSP
Chichi, your voice is breaking. It's not clear.
breaking. Is it clear? Hello?
Hello, it's not clear. Your voice is breaking.
Am I audible now?
ഇപ്പൊ കേൾക്കാം.
Yes.
Okay. So sorry for the inconvenience. First and foremost, I welcome our principal, Dr. K. R. Raghunathan sir, who has been leading us from the front. Next, I welcome our faculty coordinators of SNLC Moot Society, Sri Babu Bitovan sir and Ashwati ma'am. And next, a warm and hearty welcome to our eminent speaker, Advocate Vishwajit Anand sir, who has accepted our invitation to be a speaker for the session. And sir has participated in several prestigious national moot court competitions, and his achievements include winning the Best Lawyer, Best Male Lawyer, and Best Memorial at the prestigious National Moot Court Competition for Justice T. Ramachandran Memorial Ever Rolling Trophy, organized by the Government Law College, Thrissur, and also the Best Student Advocate, Best Memorial, and Best Quarter Finalist at Dr. A.T. Marcos Memorial Moot Court Competition, organized by School of Legal Studies, Kottayam. Now I hand over the podium to Advocate Vishwajit Anand sir. But before we begin the session, I request all the participants to please put the questions in the chat box so that we shall take them up after the entire session. So over to you, sir.
Thank you so much, Alka, and a warm good afternoon to one and all. And I take this opportunity to thank Dr. K. R. Raghunathan sir, who's also my teacher, and to Bidovan sir and Shwati ma'am for giving me another opportunity to meet you and to interact with you and to spend some quality time with you, uh, talking about one of the most favorite subjects of all time, that is called the moot court. And this is my second time addressing you people. Uh, so in the last occasion I just started, I explained to you about the moot court competition and how a moot court competition is structured and how it is being conducted, and uh, what is the qualities and what are the opportunities that a person who is being part of the moot court competition will get, and how it is going to be mold a law student to the greater extent of his career building. So all these things were discussed in the last session, and I hope at least some of you, might have already participated in the last session. That happened some almost a year back. So this time I am being invited for an orientation for the intra-level moot court competition, which is going to be conducted by from your side. So first and foremost, I congratulate the people behind for organize this intra-level moot court competition. That is the beginning of all mooting exercises, and I wish very warm. I extend my very warm wishes to one and all. Okay, so but I think at least a very few have joined. Very few have are going to listen to me for the first time. So I'm going to do justice to every kind of speakers who are participating in this today's session. So first of all, this is a 3 hours long session. So I don't want. I seriously don't prefer me the only launch speaker who is addressing. So I just need an interactive session. Mooting is all about communications. Muting is all about interactions. So I just want this to be an interactive session. That is, I'm very particular about today's event. And the second thing is that I'm going to divide the whole session into three compartments. For example, we have 3 hours, 2 to 5. So firstly, I'm going to explain to you about the mood code in general, about everything which you need to understand. The second session, okay, before that, may I know how many of you are going to participate for the intra-level mood code competition? Among the audience, how many of you are going to participate for the intra-level mood code competition? You can raise your hands. There is a raise hand option. How many of you? Because that depends. Okay. Okay. Keep on going. How many of you are going to participate? I got a list of people. Okay. How many of you are interested in participating for the intra-level moot court competition? I don't know whether the last date is over or whether yeah, the date to participate in the intra-level competition is over. I don't know. But how many of you are interested in participating in the moot court competition for this intra-level or for the coming moot court competitions? Okay, that's great. Okay, the list is getting populated. Yes, that's a good sign. So, so I believe this section won't be a fertile one. I just want this to be since people whom are interested and enthusiastic about the art of mooting. I think this session won't be a waste. This session, I just try my best to make it more and more useful for you. So I'll explain it to you how I'm going to divide the whole session and how I'm going to take the session into account. So I would like to divide this whole session into three compartments, as I said. The first, the first compartment is like to explain it to you what exactly is moot court competition, and to and make you understand to create a basic advanced framework in you about the moot court competition. So the second compartment that I would like to address is uh, what makes a student, what makes a mooter a winner. That's the second. So first, let's start with the preliminary things which are needed or there to understand what is mooting is all about before for a beginner or for even an advanced level mooter, and what makes because we participate in moot court competition. I think there are some people in this or in this audience who might have already participated in moot court competitions. I think there are some people who might have won merits in moot court competitions. So there is a difference. There is a difference for the fact that what we participate in moot court competitions, but what makes us a winner? That is the second. That is the most important thing, and also that is the second thing that I would like to deal with. And the final thing, the final compartment in the list of three is I'm going to work the problem. That means the problem that you're going to have in your intra-level moot court competition. So I already communicated to it to Alka that she will share it. The problem will be shared in the screen live. So I'll work upon the problem and I'll teach you how you have to approach a problem and how you have to work upon a problem so that it will be useful for you to do an effective, do a learned way to approach or do a competition in an effective manner. So this is the way in which I would like to begin, or I would like to organize my whole speech or whole lecture or orientation, you might say, for the purpose of the day. So, if you have any concerns at any point, this is the ground rule. If you have any concerns at any point, whether it is don't I don't what scrutinize the level of questions. You don't think like even if it is a simple question, even if it is a valid question. No, there is no comparison. Whatever you have the concern, please raise your hand or please unmute yourself and ask the question. That will make the whole session more interesting and more effective. So on that note, let me begin. So I'm not using any slides or I'm not using anything. So this whole time I'm going to speak to you straight away. So I'm not asking you, not going to ask you to switch on the videos. That is your choice. But mine will be open and you are going to watch me speak. Okay. So let's begin with saying like what is mooting? So mooting, before that, I hope I'm audible to you properly, to everyone in this session.
Yes,
I
sir,
hope
you're
I'm
audible.
audible.
Yes, sir.
Yes. Great. So, okay. Also, if you're facing any problem in terms of network or if you're not hearing my voice clearly, please let me know. Yeah. So, why we do moot court competitions? Because we have 5 years of time in a law school, in a law college, and we have almost a minimum of 5 to 4 papers in a semester to learn. So we don't have time. That's what we believe. And we have assignments, we have examinations, we have classworks, presentations, and among all these works, what is the very purpose for us to do moot court competitions? That's the first question to begin with. See, in classes, you learn subjects. You learn subjects in a very detailed manner, and that is how you need to learn. You learn theories, you learn textbooks. What makes it practical? Or do you learning it in a practical manner, or do you learning it in a way in which you need to utilize it when you practice as an advocate? That is the question. You're learning constitutional law, you're learning article 32, you're learning article 226. Have you ever thought, or have you ever in your mind, okay, this 226 and article 32 consist of different writ petitions, different kind of things. Have you ever understood how these writ petitions are being filed and how these are getting treated in a court of law? Everything like this. So have you ever practiced it in front of a class? Any of your teachers asked you to practice it uh, before a classroom? That is the point. That is what we are lacking. So moot court competitions will give you a way or give you an opportunity to practice everything that you're learning in a textbook. So what is the importance of practicing it? Because law as a subject, so why we are learning law? We need to build a career. We need to do something with it. I'm not asking you for your career options or whichever career option which is related to law need certain qualities. So moot court competitions, participating in a moot court competition can be considered as a repository, can be considered as something that gives you or something that helps you in gaining those capacities. For example, you can develop your speaking skills through moot court competitions. You can develop your research skills through moot court competitions. You can develop your interactive skills and you can develop the sense of convincing people. You can develop perseverance through mooting. So skip advocacy. Okay, skip advocacy. If you want to be an academia or if you want to join academia, you want that ability to communicate the lessons to the students, right? You need that capacity to speak or give a lecture. You need communication skills. You need the capacity to unearth certain concepts that might be unfamiliar to people. So you need research skills. So you need all these skills to join an academia, or to become an academician, or you are choosing a corporate career. You need the skill to draft a contract, or to negotiate a contract, or negotiate a legal document, or to transact a legal dealings. You need skills. Or you are working in a policy decision making sector like an NGO, or if you're working in an international if you're going to work in an international organization, you need all these skill sets together. You need to be a repository of all these skill sets. So this joining in a moot court competition or a moot court club or participating in a moot court competition will help you in developing all these skills together. So that is the answer for you. Apart from your academics or apart from what you're learning from the textbooks, you need some air to breathe. You need some occasion to make use of it. You need to bring action to those what you're learning in your syllabus. That's what moot court competitions are all about. So essentially, a moot court competition, as I explained it to you earlier, means a mock scenario is being created, a hypothetical scenario is being created in which you will get an opportunity to act as a lawyer, act as an advocate, and speak or to deal with a case. That is stepping into the shoes of an advocate, even at the stage, even at the age of studentship. So to make the whole thing's an interesting one, I'm not going to deal with the merits that you're going to get while participating in a moot court competition. Let's start with imagine all of you. Please imagine. I just want your imagination. I just want your imagination to be part of this lecture. So imagine, I don't know how many of you are participating, how many of you people are participating. I think it's like, including me, it's like 41 people are participating. Yeah, almost 53 or around 50 people are participating. Imagine this 50 people are participating in a moot court competition. Please imagine 50 people are going to participate in a moot court competition. We are going to start a story. Where it going to begin? I'm going to explain each and every step that is necessary to participate and to end or to finish or to conclude a moot court competition. Let's imagine all these 50 people are going to participate in a moot court competition. So what is a moot court competition? Moot court competition simply means you're getting a chance, a hypothetical case or a ഒരു സാങ്കല്പിക case, അല്ലെ, ഒരു hypothetical case is given to you and you are going to work. So in your college, one fine day, your honorable principal is making an so listen to this. Your honorable principal, Dr. K.R. Raghunathan sir, is like giving you a notice to every class. He's sending a notice to every class that, dear students, we got an invitation from Government Law College Trivandrum. Yeah, from Government Law College Trivandrum, that they are going to conduct a national level moot court competition for Justice V.R. Krishna Iyer Trophy, ever-rolling trophy. And I want you people, I want interesting students to participate in that moot court competition. This is the notice. This is the content of the notice. So on receiving this notice, which was issued by Dr. Raghunathan sir, your beloved principal, most of you people are interested. But most of you are not aware of what is moot court. But you heard that moot court is something, but you are interested. Some of you all have already familiar with this moot court competition, but some of you are not. So you people are giving names as interested students who want to participate. Yeah, but on seeing this enthusiasm, even Dr. Raghu sir himself was alarmed and was very much surprised for the fact that, okay, this much of students are here who are interested in participating in moot court competition. So he decided, because only one team can be sent to the competition. So he decided to conduct an internal selection process. an internal selection process. So which team emerges or which team emerges as a winner in that internal selection competition will be sent to the actual competition. So you're all like very much worried. So most of you are not aware of what is a moot court competition, how we need to approach, how can it be done. Don't worry. So Raghunathan sir is interesting someone to explain to you how to deal with the moot court competition. See, let's assume me myself as someone who is coming here to explain it to you how to do a moot court competition. Imagine, let's go back to that invitation part. An invitation received in your college. You take that invitation, you collected that invitation, and when you looked into that invitation, it consists of a moot problem. It consists of a moot problem. And that moot problem consists of, Alka, could you please share that moot problem, that is moot proposition?
Sure, sir. One second.
Yeah. If you're getting that particular invitation consists of rules, regulations, application form, and a moot problem. This is the set. And rules and regulations are those things that you need to take care of. Let's skip that part. And what is the content of that rules and regulation? That is starting from the way you need to dress up, the way you need to compile with, the things that you need to take care of, including the travel plan, including those things that you need to submit. Everything will become contented in that rules and regulations. And along with the rules and regulations, you will get an application form and a moot problem. Imagine what Alka is going to present here is a moot problem that you're going to work upon. And it is the very same problem, the intra-level competitions moot court problem. Okay, so where we reached, you got the invitation. An invitation consists of rules and regulations, moot problem, and application form. Let's skip that part. Application form. Application form is for what? For you to fill it up and send it to the competition. Send it to the host institution which is conducting the competition. Okay, so you received an invitation. One second, yes, I can see the problem right now. Yes. So I hope everyone can see what Alka is presenting, right?
Yes, sir.
Yeah. Okay. So you are not aware of anything about moot court competition. So don't look into the problem right now. Just listen to me right now, and we will go to the problem. Okay. I hope Alka, it's not a burden for you. You don't mind, right?
No, sir, not at all.
Yeah. Okay. Great. Thank you. So like you don't know anything about this moot competition. So what you decided, what you decide is that let's first go through the rules and regulations. You started reading the rules and regulations, and these rules and regulations. From these rules and regulations, you have learned that moot court competition means a hypothetical problem is given and you need to work upon this. And this moot court competition, in a national level moot court competition, one team consists of 3 people. One team, a single team consists of 3 participants. And an institution or a university can send a team. That's what. So you learned a point. Okay, moot court competition is a team event or a team game. So that I cannot individually participate in a moot court competition. I can only participate as a team. And this team consists of 3 people. Okay, point number 1. For those who are not aware of what is moot court competition is a hypothetical competition in which a created case or a hypothetical case will be given to you, and you have to work as a team which consists of 3 people. So the next question, you are very much doubtful about another thing. Okay, what is the role of these 3 people? What are they doing? And this team consists of 3 people, and among these 3, you learn from the rules and regulations that the 2 of them are speakers and the another one is a researcher. The 3 of the out of this 3, 2 people are speaker and the another one is a researcher. Okay, the second point that you have learned, okay, this is a team game, and in this team which consists of 3 people, and these 3 people are from these 3 people, 2 of them are speakers and one is a researcher. So speakers means the people who speak, and the researcher means the one who research. Okay, simple. So still you are doubtful, is this correct what I assumed? A speaker means someone who speak and the researcher means someone who conduct a research. So I'm doubtful. So let's consult with teachers. So you gone to Bidovan sir and asked him. Bidovan is a very good mooter back at college days. So you asked him, and he's an apt person to help you out. So you asked Bidovan sir that, sir, what is about these 3 people and what are the roles of these 3 people? Bidovan rightfully explained it to you that these 3 people, among what you assumed is partially correct. That means these 3 people, 2 of them are speakers who are going to speak, who are the advocates in that team, who is going to speak and present the case. Okay, so what about the other one, the researcher? So the researcher will be the one who is going to deal with, or who is going to lead the entire research process of the team. Okay, so you posted another question. Okay, so that means that the researcher will do all the research and he will give the speakers what he researched, and the speakers should frame the arguments and speak. That's what, right? Bidovan said, no, that's not what the game is all about. Researcher is not the only one who is with the duty to do all the research and he will give the product to the speakers. No, that is not how it works. It means that researcher will be someone who is going to aid the team with his expertise or with his ability to research, and he is the one who is leading the research process. Everyone should take place in the research process. So okay, you partially understood what Bidovan sir has said. Okay, so that means that everyone should take part in the research process, but the researcher is someone who leads the research process. But still you are confused. So what you properly aware of or understood was moot court is a team event, and one college can send one team, and this team consists of 3 people, and among these 3 people, the roles are one researcher and 2 speakers. That much you understood very well. There is no doubt for you. Any doubts from your part? Any doubts? Any questions so far?
No, sir.
Okay. So you understood that much. Now you decided, okay, I'll be participating. Anyway, I'll participating. So you are approaching your friend. And you ask your friend, okay, I'm interested in participating in this moot court competition. So an intra-level competition is coming. Can we form a team and participate? And what I learned from the rules that only teams can participate in moot court competition. So why don't we form a team? So your friend asked me, I haven't read the rules so far. So could you please explain to me what the rules are all about? You explain to your friend that three people can form a team, and which consists of two speakers and one researcher. You explain to your friend very well about the entire thing. So your friend said that, okay, I am also interested. I am also interested in this process. Let's join hands and participate in this book competition. So both of you are saying that we need one more person. We need one more person. So you both have a mutual friend. You conveyed it to your mutual friend, and she agreed in a jiffy that she's also interested. So you three partially right now formed a team, but you people don't know the individual capacities, who will become two speakers and who will become the researcher. So the next task on your end is to fix your capacity. That is the most important thing. When you participate in a Moot Good competition, this is what I want to say to you. Don't, this is a golden rule. See, why I am skipping the earlier, because I already had a session last time which explained to you about what are the merits of Moot Good. So I am skipping that part. This is an advanced training. So when you participate in a Moot Good competition, this golden rule is that never do. There is a mistake. There is a mistake in this setup. I'll explain it to you. Never consider this Moot Court competition as something for the sake of your friendship or something. You friends can become Moot Court partners, and that is one of the good combination, because you being friends, you will have that freedom, uh, you will have that rapport, everything will be there. But don't fall to the extent, or to the extent of your friendship. That's what it is, the golden rule is all about. So here, these people, these three of the team, don't know what which are the roles. So they started introspecting. Within them. What is the best capacity? Because we both, all three of you are interested in voting, no doubt about it. So what is the best suitable capacity? What is my capacity? So am I good at speaking? Am I good at convincing people? So they, all three of them had an introspection. So one of them, and they had a meeting, they had a chat, they had an informal conversation among them. From that informal conversation, they reached into a conclusion that, okay, one person from that team said, I'm very much confident about my speaking skills. And from early childhood onwards, my parents are saying that I'm very good at convincing. So I think I can be a speaker more than a researcher. My reading skills are a little not up to the mark. That doesn't mean that I cannot read, but the speed of reading, the understanding, the time taking, the time required to understand something are all a little not up to the mark. But I can speak. If I understood a particular concept, I believe in myself that I can convince even to a person who's not that much easy to crack. So, okay, the second person is also saying that I'm good at both. I can be a researcher if I can speak as well as I can do research. But the third person said that I can read, but I have some confidence issues. I have some confidence issues in conveying things. That doesn't mean that I don't know how to speak, but I have some confidence issues in conveying things. But I think I can read, and I can very well research, and I can make, if I become a researcher, I can become more productive. So internally, you reach to this conclusion, so that uh, two people, the person who believed himself as a good speaker, and the other one who is flexible, will become the speakers, and the one who is who's having a little confidence issue will become the researcher. Okay, they are happy. There is no like fight for a position. There is nothing like that. So the team is formed with. There are two problems in this setup. From the point of view of those people who are conducting the Moot Court Society, we won't let this happen. Why? Because the first one is confident about his speaking skills, but he is not that much confident about his research skills. At Moot Court Society, if these people are coming to me and asking them, will this setup will work out? I would deny it. I would say the person who is having some confidence issue will become a speaker, because mooting is some avenue in which you can develop yourself. If you have confidence issue, do moot. This is the occasion in which you can bring on, you can sharpen your confidence issues. Why? If you become a lawyer or an advocate, a real-time advocate, you are burdened with the life of your client. You cannot, nobody will excuse yourself for the fact that you do have confidence issues. But here, this is hypothetical. This is something cooked up. So even if you fail, even if you are affected with your confidence issue, no problem. You have another opportunity. Nobody's life is at stake. Nobody's revenue is at stake. So this is an opportunity. This is an opportunity in which you can build up every possible shortfalls that you are lacking. That is a point. So everyone should move. Just throw away all your reservations. I do have confidence issues about speaking. I do have issues with research, and also I would advise that person who said that I have good speaking skills, but I don't know. I lack in doing research. I would specifically make that person as a researcher in that team. Even if the team didn't perform well, I don't care. But I will make him as the researcher. But for what? Teach him how to do the research process. So the message, so what I would like to share, or what the nutshell is all about, mooting is an avenue it is a factory that makes a student a lawyer. So after the course, this is just a test ground. This is just a factory. Factory is a place in which a product is formed. So the durability, the real actual test ground is the market, and after the usage, the hands of the client. So this mooting is one factory that mold you as a advocate or as a legal person. So everyone should do moot. Okay, let's come back to the story. Okay, anyway, since this is an intra-level moot court competition, your teachers permitted this competition. So the person who is confident with speaking will become the speaker, and this team is anyhow you manage to get permission from your faculty concerned, and you're doing you're keeping yourself doing the moot. So right now, what are the things you have? You have a team. You got a team at hand. You got a problem proposition, that is moot proposition, which is almost similar to what you're seeing in the screen, and you have a competition, you have a deadline, but you don't know how to start, how to begin, and what are the things. So again, to get a clear picture, you decided to read the rules and regulations once more. See, Alka, if it is a problem, then I'll ask you at that time. You can show the screen. You can right now stop the presentation. I'll ask you if it is a problem. I think you're doing multiple things out there. I'll ask you at that time.
Yes, so some of them are joining now, that's why.
That's not a problem. Please stop the presentation. I'll ask you at that point of time where you can start your presentation. Okay?
Okay, sir. I'll do it in the last hour, that is from
Yeah,
3,
yeah,
4
yeah, yeah.
o'clock to 5 o'clock.
That is fine.
Okay.
Okay. Yeah. So you got a so right now, like you got a problem at hand, but you don't know how to work or how to do the like um, how to start, how to begin, how to do it. Those things you are not that much familiar right now. So you decided to read the rules once again. You took the rules and regulations. You understood that. Okay, first step in the moot court competition. The moot court competition is a twofold game in which first, before the competition, you need to submit a draft. You need to submit a written submission in the first place. And based on the written submission, you are going to argue. That's what you learn from the rules and regulations. And you have identified the fact that there are dates. For example, the submission dates are already given. So you understood that, okay, we formed a team. So we first need to submit a written submission. And then only we can argue. So what is this written submission? What exactly is this written submission? And in the rules and regulations, the term used to define this written submission is as memorial. It as memorials. So what is this? And it is stated that two memorials need to be prepared. You have to prepare two memorials. So why we need to prepare two memorials? We are only one team participating in this competition. Why should we prepare two memorials? That might be a mistake you assumed. So you are again contacting either Ashwati ma'am or Vidhovan sir, and they explained it to you that no, you are the one who is wrong. They have rightly pointed out you have to submit two memorials. Still, you are getting confused. Why? Why we need to conduct two memorials? You asked a question again to them. They asked, don't come to us. You are not doing any work. Please read. Everything is there. Go and read. So you decided, okay, let's read. You're going back, entering into the library, finding a remote corner, and you're sitting there, started reading the rules and regulations together. So you identified that. It said that two memorials, one for the petitioner side or the one who is filing the case, the other one for the opposite side, the respondent. So you identified that, okay, you got something is coming to your mind. Okay, this is a moot court competition. That means this is a case. A case obviously consists of two sides. That means the one who is filing the case as well as the one who is defending the case. Okay, now you understood. Okay, fine. That is why we need two memorials. One is for the person, one is for the petitioner, and another is for the respondent. That means one is for the person who files the case, the another is one for the for the opposition. Okay, now I got it. And you check the problem. You checked the moot proposition, and you identified that okay, there are two parties are involved in the problem. That is why you need to participate. You need to prepare two memorials. So okay, let's stop the story right there. So moot court competition, as I said to you, this is me myself. I'm talking to you with the story aside. Let's keep the story aside. This is an explainer. So moot court competition, for your kind knowledge, is a hypothetical case which is reaching to you for your work. So you need to form as a team, and the problem, the proposition consists of two sides or three sides or four sides. That is, but definitely there will be two sides. ഒരു വാദിഭാഗം ഒരു പ്രതിഭാഗം എന്നിങ്ങനെ രണ്ട് ഭാഗങ്ങൾ കാണും. I hope nobody from the audience ആർ നോൺ ലൈക്ക് മലയാളം മനസ്സിലാക്കാൻ പറ്റാത്ത ആരും ഇല്ലെന്ന് വിചാരിക്കുന്നു. എല്ലാവർക്കും മനസ്സിലാവുമല്ലോ അല്ലേ?
Yes, sir.
ഓക്കെ. അപ്പോൾ ദർ ബി ടു സൈഡ്സ്, ലൈക്ക് ഒരു വാദിഭാഗവും ഒരു പ്രതിഭാഗവും ഉണ്ടാവും. അപ്പോൾ ഇവർക്ക് രണ്ടുപേർക്കും വേണ്ടി നമ്മൾ മെമ്മോറിയൽ വി നീഡ് ടു പ്രിപ്പയർ മെമ്മോറിയൽ ഫോർ ബോത്ത് സൈഡ്സ്. അപ്പോൾ ഈ മെമ്മോറിയൽ എന്ന് പറയുന്നതാണ് നിങ്ങളുടെ റിട്ടേൺ സബ്മിഷൻ. റിട്ടേൺ സബ്മിഷനെ ബേസ് ചെയ്തിട്ടായിരിക്കും നിങ്ങൾ ആർഗ്യൂ ചെയ്യാൻ പോവുക. ഓക്കെ, യാ. എനി ക്വസ്റ്റ്യൻസ്? എനി ക്വസ്റ്റ്യൻസ്? See, this is an open session. You can ask any questions. എന്ത് ക്വസ്റ്റ്യൻസ് വേണോ നിങ്ങൾ ചോദിച്ചോളൂ. കാരണം മനസ്സിലാക്കി ഒരു സ്റ്റോറി പോകുന്നത് പോലെ നമുക്ക് പഠിച്ചു പോവാം. എനി ക്വസ്റ്റ്യൻസ്? Two things: either you are not understanding anything or else you are getting the point. What should I assume? The first or the second?
It's clear,
No
sir.
questions as of now, sir.
Yes, sir, it's clear.
Great. Yeah. So yeah, fine. So thank you. So yeah, let's come back to the story. So right now you understood. You something is clicked into your mind that okay, there are two sides, and we need to prepare for two sides. Then the next question that turned up inside your mind that should we need to present for both the sides? If so, that would be very difficult. That was the thing that came to your mind. Okay, so like if it is for the one side, okay, we can practice for the one side thoroughly, and to the entire stretch of the competition we can be that side, so that it will be more easier. So we are preparing for both the sides. Should we need always നമുക്ക് രണ്ട് സൈഡും പ്രാക്ടീസ് ചെയ്യും? രണ്ട് സൈഡും എന്തിനാ പ്രിപ്പയർ ചെയ്യണേ? ഞങ്ങൾ ആദ്യമേ ഒരു സൈഡ് എടുത്ത് അത് പ്രിപ്പയർ ചെയ്ത് അത് നല്ല രീതിയിൽ പഠിച്ചു പോയാൽ പോരെ? That was a question that emerged in your mind. So you read the rules once again. You understood that according to the rules of the competition, you have to argue for both the sides. That's what you understood from the competition. You have to argue for both the sides. Okay, let's keep the story a little aside. ഇനി നിങ്ങൾ എൻ്റെ അടുത്ത് ശ്രദ്ധിച്ച് കേൾക്കുക. ഒരു moot court competition-ന്റെ rounds. A moot court competition consists of a national level moot court competition consists of multiple rounds. അപ്പോൾ ആദ്യം ഒരു national level competition-ൽ it consists of multiple rounds, and the first round is the preliminary round. The first round is the preliminary round. And in this preliminary round, which consists of, അത് എന്താണെന്ന് ചോദിച്ചു കഴിഞ്ഞാൽ, in this preliminary round, you have to argue for both the sides. ആ preliminary round കഴിഞ്ഞ് അടുത്തതിലോട്ട് പോകുമ്പോൾ the next round is quarterfinals, and the next round is semi-finals, and then the finals. So preliminary, quarter, semi, and finals. This is the structure. So when you go and participate, you have to, for example, let's take a competition in which 20 teams are going to participate. ഒരു കോമ്പറ്റീഷനിൽ 20 ടീംസ് ആണ് പാർട്ടിസിപ്പേറ്റ് ചെയ്യാൻ പോകുന്നത് എന്ന് വെച്ചോളൂ. So the first round, the first 10 teams will participate. The first round of the preliminary competition, the first 10 teams, ആദ്യത്തെ 10 teams will compete against the next 10 teams. അതായിരിക്കും ഫസ്റ്റ്. ആദ്യത്തെ 10 ടീംസ് അടുത്ത 10, അപ്പൊ 1 മുതൽ 10 വരെയുള്ള ടീമുകൾ 11 മുതൽ 20 വരെയുള്ള ടീമുകൾക്കെതിരെ മത്സരിക്കും. That's what it is. So the first 10 teams, that is the teams from the 1 to 10 will participate sorry for the trouble. So the first 10 teams, that means 1 മുതൽ 10 വരെയുള്ള ടീം അടുത്ത 11 മുതൽ 20 വരെയുള്ള ടീമുമായിട്ട് മത്സരിക്കും. അപ്പോൾ പ്രിലിമിനറി റൗണ്ടിൽ 1 മുതൽ 10 വരെയുള്ള ടീം പെറ്റീഷണർ ആയിരിക്കുമ്പോൾ 11 മുതൽ 20 വരെയുള്ള ടീംസ് എതിർഭാഗമായിരിക്കും, റെസ്പോണ്ടന്റ് ആയിരിക്കും. അതേപോലെ പ്രിലിമിനറി റൗണ്ടിൽ അടുത്തൊരു റൗണ്ട് കൂടെ കാണും. അപ്പോൾ ഈ 11 മുതൽ 20 വരെയുള്ള ടീമുകൾ 1 മുതൽ 10 വരെയുള്ള ടീംസുമായിട്ട് ജമ്പ് ചെയ്തിട്ട് വീണ്ടും മത്സരിക്കും. അപ്പോൾ ആദ്യം പെറ്റീഷണർ ആയിരുന്നവർ രണ്ടാമത്തെ റൗണ്ട് വരുമ്പോൾ റെസ്പോണ്ടന്റ് ആവും. ആദ്യം റെസ്പോണ്ടൻസ് ആയിരുന്നവർ രണ്ടാമത്തെ റൗണ്ട് വരുമ്പോൾ പെറ്റീഷണർ ആവും. ദാറ്റ് ഈസ് എ സ്വിച്ചിങ്. ദാറ്റ് ഈസ് വൈ യു നീഡ് ടു പ്രിപ്പയർ ഫോർ ബോത്ത് ദ സൈഡ്സ് ആൻഡ് യു നീഡ് ടു ആർഗ്യൂ ഫോർ ബോത്ത് ദ സൈഡ്സ്. ഇനി നമുക്ക് സ്റ്റോറിയിലോട്ട് പോവാം. Let's go back to the story. So they understood that they need to prepare for both the sides and they need to argue for both the sides. They understood this. So, okay, they are taking it as a challenge. As a team, they are going to work. So they started working on the problem and they are going to start working on the memorial, and they prepared a memorial. They prepared a memorial. And this memorial preparation മുമ്പ് അവർക്ക് അറിയില്ല എങ്ങനെ ആയിരിക്കണം ഒരു മെമ്മോറിയൽ എന്നുള്ളത്. They don't know how to, what is the structure, what is the format. These people don't know. So they again decided to read the rules. And they understood that a memorial is a unique document which do have a format, do have a specific format. And they can only work upon that format. They identified that a memorial do have the rules and regulations consist of this format. That means a memorial do need a cover page. What I'm saying is the format of the memorial. A memorial should need a cover page, and the memorial should have a content page. The memorial should have a page which is dedicated to list all the authorities that you are citing in your memorial. That means the references that you are citing in the memorial. And the memorial should need a page to say that what is the jurisdiction of the court. And the memorial should need a page or multiple pages exclusively dedicated to explain the facts of the case. And summary, that means the summary of the facts. And memorial should need a page or multiple pages which are there to explain the summary of your arguments that you are building in that memorial. And a exclusive part should be dedicated to explain the arguments in detail. And at the end, to conclude with, the memorial should contain a page that is dedicated for the prayer. That means what you are going to plead before the court. They have learned this structure. You don't have to be confused. When you started doing the Moot, you will understand. So this is the format. I just simply explained to you the format. That's all. So that is how the format of the memorial looks like. They identified it. They learned it, and this team prepared 2 memorials. This team prepared 2 memorials. One is for the petitioners. The other is for the respondents. So now they know. Now they are a little more confident. Okay, they have prepared 2 memorials, and the memorial is according to the format it needs and it requires. They have prepared it. Let's keep the story aside. Let's listen to the explainer. Please listen to the explainer. There are certain rules. When you prepare for the memorial, you should be the first essential thing that is there, that is necessary for you to conduct, is that read the proposition that we are going to read after the session, after this compartment. Read the problem as much as possible. Read the problem as much as possible to ascertain the facts, to ascertain the problem, the real legal issue behind it, and to bring upon a good work. And conduct, the second part is that conduct an effective research. Conduct an effective research that aid you, that helps you in the process. Then execute it. After conducting a research, execute it. Execute it in the form of your work. That means write it. Write it in a very manner in which anybody, even a person from the legal background or even a lay person, could read and ascertain it. Substantiate it with law and frame it as a good argument. That is how you need to draft a memorial. And if we can have if people want, we can have a detailed and exclusive session dedicated for memorial writing. That's we can make it possible. Okay, so at that time we can discuss all these things. So these are the things which are needed for a good memorial. So excellent understanding about the problem. Excellent means logical and rightful understanding about the problem. That means a proposition. And excellent research, good and effective research, and apt articulation. These are the things which are very much necessary and required for the memorial. So yeah, let's go back to the story. You have right now the story. You have right now the two memorials at hand. And these two memorials, through these two memorials, what you're going to do? That means you're going to submit to the for the intra-level competition. And there is a deadline for the submission of the memorial, and you submitted it within the deadline or beyond, or not reaching the deadline. You submitted it, and after a few days, you learn the fact that okay, your team is being shortlisted, because so many teams are right now participating for the intra-level competition, and your team is shortlisted. That means you are partially selected. But this is one thing. In most of the competitions nowadays, they will conduct a memorial rounds. For example, first you need to submit the memorial. That is to bring quality. Based on the quality of your memorial, you will be either selected or dismissed from the competition. Based on the once they refer into the memorial, they could very much understand the quality of the research that you have conducted, the method of your working. Everything can be ascertained from the work, the quality of your memorial. So that right now, fortunately, your hard work paid off. So your team is selected for the intra-level competition. Right now you are excited. At the very same time, you are very much tensed. Right now the things are getting serious. You're selected for the competition and you have prepared a memorial. And now what is next? You refer the rules. The next thing is arguments. You have to come to the competition and participate in the competition. Well, let's compare it with whatever we have discussed, whatever we have assumed, whatever we have, whatever I just tried to convey to you. Let's compare it with a national level competition. A national level competition is also going through this way. First, after getting an invite, you need to work on the memorial, and you need to first register for the competition. You need to prepare the memorials. After sending the memorial, once you receive the assent or selection, you need to participate for the oral rounds. That means the speaking rounds. So for the speaking rounds, prior to the corona, there was only a very few online competitions around the nation was there, and if these online competitions are a rare business. Most of the competitions are 99% of the competitions are held offline, but nowadays it's only online competition. So I don't know what is the mode of your intra-level competition, either it is online or offline. But for offline competition, you at the time of the competition, you need to visit the hosting institution. For example, a team from your college is coming to Trivandrum to participate in a government level, in that government law college moot court competition, you will be hosted. The hosting institution will provide you the stay, decent stay will be provided. And that is the spirit. That is a fun of competition. And if you go to, you can all India level, there will be competitions. So they'll provide you the stay, they'll provide you food, everything will be covered in that registration fees. And registration fees won't be that much that much high. It will be around 3,000 per team or 5,000 per team. And like uh, what I'm saying is the usual standard. And very famous institutions will offer you like very famous amenities out there. They'll manage you to bring stay at some good hotels or centers, and you can stay there and you can participate in the competition. Everything will be covered until the last day of the competition. And the structure of the competition will be, it's a three mostly the competitions are conducted for 3 days. The first will be the inaugural day, in which only the inaugural ceremony will be there, and along with that there will be taking of lots. That means, or fixation of the team and fixation of the schedule. That means in the preliminary round, which team will be against participate against which team, and in the first round, which are the teams who will be represented as petitioners. Those things will be decided in the first day by picking of lots. And the second day onwards, the competition will begin. The first day they'll conduct the preliminary rounds, quarterfinals, or time according to the time, the semi-finals, and the third day will be dedicated for the finals. This is the structure in national level competitions. So you are right now participating for the intra level competition. Your team, come back to the story. Your team is right now uh, training or preparing for the selection rounds of the speaking rounds. So right now you are practicing. So basically, what is there? What is there means, basically, in an oral round, if you enter, I'll right now, the day has arrived. The day has arrived. That means the final selection round day has arrived. So you're going to participate the first ever moot court oral rounds in your life. Okay, I'm going to split the explanation into two. That means, if this intra-level moot court competition was offline or if it was online. So suppose let's assume. So what is the mode of your intra-level moot court competition? Is it offline or online?
It's online, sir. Virtual.
Yeah, yeah, virtual. So suppose you are participating in an offline mode of competition. I'll explain it to you, the whole setup. The first round, there will be an opponent, and at the time of your competition, you will be like leaded to a room, which is, that room will be converted into a setup of a court. They will prepare the entire setup. They'll arrange to prepare the entire arrangements to make it look like a courtroom. There will be higher platforms which will be prepared for the judges to sit. There will be places for the court officers. There will be positions will be arranged for you, both the teams. That means both the sides to sit, and there will be also places will be arranged for the audience to watch, exactly like a courtroom. So let's imagine you're having a first online offline selection round, offline selection section. So you will be invited, or you will be leaded to sit. That means the center of the room, there will be a higher pedestal in which the judges will sit, and just below the judges there will be one table. That is for the court officers, and facing the judges there will be two positions, two benches, or two in which three chairs for three people, two the speakers, and the one researcher will be placed for both the petitioner side as well as the opposition. So the first, you will be seated in a place. You will be seated in a place that is dedicated to you. And when a time, the judges will enter and the competition will begin. This is how the setup. But for online competition, you will be sitting at the comfort of your place, just like in an online hearing. The judges will come, and at that point of time, you need to start arguing. Okay, let's come back to the situation. Let's come back to the story. So at this point of time, you're going to participate in a moot court competition for the first time. You need to you are the petitioners in that case, that particular round. Petitioners are the one who's opening up the arguments. So the first speaker will open up the arguments. The first speaker will open up the arguments, and he will conclude, for sure he will conclude his arguments, and the judges will ask questions, and you are in a place, you are in a position to explain to the judges clarifications. And after your time, permitted time, the second speaker will speak, and the entire issues in your problem, I'll explain it to you what is an issue when we discuss the moot proposition. The entire issues will be discussed between two speakers, and then the opposition team will speak. And after the opposition team finished his side, there will be a little time will be provided to you for clarifications or for defending your side. For both the teams, we call it as rebuttals. This is the arrangement. This is how the oral rounds work. And based on your performance, the marks will be provided to you. And you will get the marks. And most of the competitions, the marks will be based on who the either the total aggregate score among all the participants, or in a particular courtroom which team wins. That will be the modus of operandi in accordance with the rules of the hosting institution. Okay, any questions so far? Because what we are going to do next is to discuss the problem, and afterwards I'm going to explain to you how you need to work upon and what are the rest of the things needed to be conducted or done. So any questions from your end? Any questions, any doubts? Because some of you are going to participate for the selection round. Any questions?
No, sir.
Okay, great. So Alka, could you please start broadcasting the problem?
Sure, sir.
Yeah. Thank you.
Sir, I hope the screen is visible.
Yes, it's visible. What about others? Is it visible for others?
Yes, it's visible.
Yes, sir.
Yeah. Yeah.
Yes,
So,
sir. Yes, sir.
so this is this is to be honest with you, this is for the first time I'm seeing this problem. I haven't read this problem, so this came to my mind that okay, why don't we discuss this problem? So let's crack this problem together, and I'll explain it to you how you need to approach this problem. This is how a problem looks like. Let's go back to the story. Please remember the first time when you receive the problem and how you need to work upon. So I just want every one of you, this is a workshop let's work this as in a workshop mode. Uh, I just want everyone who's present here to read this problem. Okay, to read this problem in the first place. Only two. I think it is only 2 pages, right? So read this problem. I'll give you 10 minutes to read this problem. I'll give you 10 minutes. So read this problem in the first place, and afterwards let's work upon this problem. Okay? Yeah. Alka, please send me in my WhatsApp. Please send the problem as well. Okay?
Sure, sir.
Yeah. So this is, please do remember, this is an interactive session is going to happen. I just want you people to be benefited out of this. So I just want you people to read this problem. So I'll stop my session by 4:30, and the rest of this half an hour is for doubt clearance and Q&A. So it is only just 1 hour more. Within this 1 hour, I just want you people to ascertain, make you people ascertain about the problem, or to be keep updated about the problem. So please read this problem. And if
Sir,
you
a
want,
few of them have requested to join. So shall I admit them?
yeah, yeah, very well, please.
Thank you.
Yeah, if you want the screen, that is, if you want the page to scroll or make any changes in the page, please unmute yourself and say the Alka will do the necessary. Yeah, start reading. You will have 10 minutes. Right now in my watch it is 17 past 15. So you can we can you have time until 3:30. Right now it is 3:18. So you have time until 3:30. By 3:30 you need to finish reading the problem. The time starts now. Also, if you could ask any doubts if you're finding any problem or if you're finding it difficult. It's a very short problem. It's not lengthy at all. I'm giving you this much time just to read it properly. Yeah. So if you're finding it difficult, please let me know.
No, sir, no problem.
Yeah. So have you finished reading?
Yes, sir.
Yes, sir.
Great. Yeah. So so let's work upon this problem. Like let's read it together. That would be so. This is how there are. My purpose is twofold. One is just to understand or make sure how to approach a problem. The second thing is that to help you in the process of preparation for the intra-level moot court competition. So as you raised your hands, there are some people who are going to participate in the moot court competition. So that's why. So this is like the problem is just like this. This person called Vinayan, uh, yeah, he's an urban youth living in Calicut district in the state of Kerala. And after completing his secondary school education, this guy Vinayan became an unskilled laborer, primarily working uh, in construction sites. Due to the pandemic, work opportunities became scarce and started affecting Vinayan's livelihood. In order to sustain himself and his family, he took up the job of a delivery partner, as he owned a two-wheeler of his own for Good Food, and which was an online food delivery company owned by the government of Kerala. Once in the middle of a delivery gig, Vinayan suffered an accident and sustained injuries. Vinayan claimed compensation against Good Food upon the premise that accident occurred during the course of employment. Good Food denied the claim on the ground that delivery partner is not an employee of the company. Okay, from this, from this much, so leave the rest of the parts, the issues which are identified and all. Just leave this part. Please, what are the core issue? What is the core issue which forms part of the first paragraph? What exactly is the core issue which forms part of the paragraph? Can anyone please let me know? If you are lawyers or if you are advocates, if Vinay is coming to your office or your chamber, what will you advise? What will you identify as the core issue? Let's keep the second paragraph and the issues. From the first paragraph, what will you identify as the issues? Could you please explain? Could anyone volunteer?
People facing
problems in unorganized sector.
Okay. People's problems, the problems faced by people in the unorganized sector. Okay. Yeah. Then,
Then whether
Sir,
Vinay is entitled for the compensation.
I beg your pardon. Could you please repeat?
Yes, sir. Whether Vinayan is entitled for the compensation, that is, does he fall under the term called employee under this Code of Social Security? That is,
Okay.
yeah, yes, sir.
Yes, I got your point. Yes, whether he's entitled for compensation, since whether he falls under the ambit of or the context of an as an employee. Yes. Then, then, anything else? Please open up. See the forget about those conventional things. Forget about those issues which are mentioned. Please, if you feel like is there any other issues, more and more issues turns up, the case will become more and more strong. So please, what are the issues?
Whether a
sir,
fundamental right being violated,
Whether
a fundamental right being violated.
okay, whether the guaranteed fundamental rights are being violated. Yes. Okay. Yes, Bijoy, you started saying something.
violation of natural rights, natural justice, violation of natural justice.
Okay. Well, if there is any violation of natural justice is involved, yes, true. Then
Uh, I have a question. Like,
sure, please.
see, these workers, they are doing their work on their choice then. So, uh, I just want to confirm, like, as they are doing it online, I mean, uh, he is having the choice of employer, right? So multiple apps are available. So,
I'm
whether,
not getting. Listen, your voice is breaking, and I'm not uh, clearly understanding it. Could you please repeat it once more?
yeah,
The
like,
background noise is very.
I have a doubt,
Yeah, please.
as because see, as it is happening, uh, I mean, this work is during his. I mean, he is doing the job online, right? This big worker, he is doing an online delivery of food only. So multiple apps are available, like Zomato, Uber. How many apps are available? So how can we know that we have got this accident during this particular, I mean, whether he was serving during the delivery of this
Yeah, I'll help you out in the question.
yeah,
I'll repeat. I'll reiterate what I understood from your question. Basically, your question was like there are so many service
yeah,
providers are available in the market, like the counterparts of this good food. So how come
yeah.
it is so sure for the fact that at the time of the happening of this accident, this person worked exactly for
But
this good food? That's what your question is all about.
yes, yes, yes. Because multiple apps you can, I mean, a person can download so many apps and same time he can do the work simultaneously.
Okay,
Simultaneous
okay,
delivery is possible. So
okay,
how can we assess
okay.
the
Yeah,
accident happened?
yeah, understood. Yeah, I'll get back to your question. Okay, I'll answer everything. I'll deal with all your concerns, all your questions, and all your observations collectively after finishing up the entire after taking entire people's opinion. Yeah. Anything else? Any other observations or any other?
So whether this good food is responsible for the accident happened to Vinay.
Okay, whether this, yeah, fine, yes. Okay,
Sir,
Whether
is
the
there any
accident took place
application of
during the course
vicarious
of the
liability?
employment.
okay. First, I'll listen to Geeta. Your question was like whether this accident took place at the course of his
During the
employment.
course of the employment, yes.
Okay, yeah, yes. Then, Aparna, you please.
Sir, is there
You said,
any existence of vicarious liability?
yeah, whether there is any scope for vicarious liability. Yes. Okay. Then, anything else? Any other questions?
Whether we can file a fee.
Whether we can file a public interest
Fee.
litigation petition.
Yeah,
Yes.
because the social security, I mean, like when there is a clear status, the thing is whether it is maintainable or not.
Okay. Okay. Yes. See, all these, okay. If there are no questions left, then I can start explaining. I can move on to the explanation part. Is anybody has any questions? You people having any questions? Okay, yeah. If you have any, please feel free to raise any questions. Okay, so I have listened to all your observations, all your questions, and all your concerns and doubts. Let's collectively approach this. Once again, let's read. Like to the question that let's begin with the question. Like there are multiple vendors. There are multiple vendors whom are available in the same arena. So how come he can prove the that this happened when this incident was happened? He was working with good food. That was the doubt. That was the question. Okay, so see, somebody has observed whether this public interest litigation. I think right now. Am I audible?
Yes,
Yes,
sir.
sir.
Yes,
Yes,
sir.
sir.
Okay. So there are certain these questions like
Hello, sir.
am I audible now?
Yes,
Yes,
sir.
sir.
Yes, sir.
Yes, sir.
Yeah. So these questions, let's take collectively these questions together and discuss. See, first of all, let's move on to the problem once again. Like this person is an urban youth living in Calicut district in the state of Kerala. After completing his secondary education, school education, this person became an unskilled laborer, primarily working in construction sites. Due to the pandemic, work opportunities became scarce and started affecting this person's livelihood. So, in order to sustain himself and his family, he took up the job of a delivery partner. That means he took up the job of so until this part, what's he saying? This person as a youth in a district of Kerala, and he only do have secondary school education. His qualification, his educational qualification is that much, and he became an unskilled construction worker. And when it was fine, everything went fine. But at the time of pandemic, when pandemic was striked, he became jobless. At that point of time, what he did was he took up the job of a delivery partner. So who is a delivery partner? Delivery partner, we know what the delivery partner is doing. Like like when we order in a food delivery app, somebody who comes to our place and give the food delivered. That's what the job is called for. So he took the same job, and the company that he employed with is Good Food. That is an online delivery company owned by the government of Kerala. Once in the middle, these are all the explanation part. Until which these are all the explanation part. Once in the middle of a delivery gig, that is like this person suffered an accident and sustained injuries, and which was happened in the middle of a delivery process. And the when this person claimed compensation against Good Food upon the premise accident occurred during the course of the employment. So the Good Food denied the claim on the ground that delivery partner is not an employee of the company. See, this is the part. Every problem is structured in a way. It starts explaining things. For example, here it started with the geography. It started with a person who is living in this part of the place, this part of the state, and what was he doing, and what are certain background informations about him. Uh, what is his educational qualification, and what is the storyline? What are the facts involved? This is the format in which a problem is being prepared. So the first parts, certain parts of the problem, you might feel like, okay, these things are not useful per se for the problem, but these things are certain facts which might be useful or which are useful for the whole creation of arguments. So here in the first few parts of the problem, it said that this guy who residing in a particular part of the state had a job which was in an unskilled as an unskilled worker in the construction sites, and he met with the problem that he was not having enough job due to the pandemic, and he started doing another job. So that is fine. It's not at all problematic. That is something common happened to most of the people during the time of pandemic. That is fine. Where is the issue involved? So I'm just asking you to how to deal with the problem. So until this part, so when you get a problem at hand, you need to search. Every line is important. Every line is important. You need to bifurcate. You need to experiment with every line. So the first line, he was a youth. What what is the issue? What is the legal issue? What is the factual issue? What? No issue at all. Okay, that is safe. Let's move on to another uh, part of the problem. Another second line. He had an education. He had only a secondary school education. Okay, secondary school education. Let's underline it. That shows his educational qualification. If the coming part of the problem in which if the issue is something which is related to his education, then we can make use of this point. So just underlining it. I'm just underlining it. And then he's an unskilled laborer, primarily in the construction site. Okay, he's unskilled. Okay, his educational qualification is until secondary education, and he is an unskilled laborer. Okay, I'm just underlining. I'm also underlining it. So even though I'm underlining all these things, I cannot identify a legal issue out here. No problem. Okay, these are all things. These are all common things. And then due to pandemic, okay, pandemic is also now common. Work opportunities became scarce. Okay, this is also not unfamiliar to us. This happened in everyone's life. I cannot find an issue until this part. So in order to sustain himself and his family, he took a job as a delivery partner, as a delivery boy or a delivery partner in a company. Okay, that is also fine. Until this part, I cannot identify a legal problem, identify a legal part, legal issue. So then comes once in the middle of a delivery gig. Okay, now I'm just getting the sense that, okay, some kind of a problem is going to be explained. Okay, I should be more careful. Okay, until this part, everything was fine. I could not identify. I don't know whether anything is implied, but so far my mind is not seeing anything problematic out there. So, but now when I started reading this part onwards, once in the middle of a delivery gig, so I'm just assuming that something is going to come. Okay, let's read it. Once in the middle of a gig, this Vinayan suffered an accident and sustained injuries. Yes, it is a problem. Okay. This is something, loss or a damage or an issue which happened to Vinayan once in the middle of the gig. Vinayan suffered an injury and Vinayan suffered an accident and sustained injury. Okay, now it is problem, so I need to be more careful in analyzing this sentence. I'm taking every word into consideration. Once in the middle of his job, of his delivery job, that means that, okay, in the middle, that means he's taking part of the job. So he's right now, wherever he's doing the job, he was an employee of that concern. So this is an accident which happened during the course of his employment. Okay, I'm just writing it down. Okay, accident happened during the course of his employment. I got a point. So suffered an accident and sustained injuries. Okay, as part of the accident, he suffered injuries as well. Okay, now it is an issue. So we will get more clarity after reading the further points. Okay, Vinayan claimed compensation. So Vinayan claimed compensation against good food. Vinayan claimed his compensation against good food. So so Vinayan claimed compensation against good food. So he is claiming compensation from his employer. So let's connect the earlier part with this. That means that he experienced this accident. He experienced this accident. He underwent this accident during the course of his employment. So because of that reason, he is claiming compensation from his employer. Okay, fine. I connected the dots. Okay, yeah. But good food denied the claim. The good food is not ready to give compensation to Vinayan for the fact that the delivery partner is not an employee of the company. This delivery partner is not an employee of the company. So, what the counter or what the defense that the company is saying that Vinayan പറയുന്നു അദ്ദേഹം ജോലി ചെയ്ത സമയത്താണ് ഈ അപകടം സംഭവിച്ചത്. അപ്പൊ അതുകൊണ്ട് എന്റെ തൊഴിൽ ദാതാവ് എന്ന നിലയ്ക്ക് ഗുഡ് ഫുഡ് എന്ന് പറയുന്ന ആ ഗവൺമെന്റ് കമ്പനി എനിക്ക് കോമ്പൻസേഷൻ നൽകണം. അത് വർക്ക് കണ്ടീഷന്റെ ഭാഗമാണ്. ആ ഒരു തൊഴിൽ ചെയ്യുന്നതിന്റെ ഭാഗമായിട്ടാണ് എനിക്ക് അപകടം സംഭവിച്ചത്. അപ്പം ഗുഡ് ഫുഡ് പറയുന്നു അല്ല, ഡെലിവറി പാർട്ട്ണർ എന്ന് പറയുന്ന സംഗതി അതൊരു ഫുൾ ടൈം എംപ്ലോയ്മെന്റോ കമ്പനിയുടെ എംപ്ലോയി അല്ല, കമ്പനിയുടെ തൊഴിലാളി അല്ല, അതൊരു കോൺട്രാക്ടിന്റെ പുറത്ത് തൊഴിലാളി അല്ല. അപ്പൊ നിങ്ങൾക്ക് now it is clear, right now it is clear, you got an issue. So what is the issue? This person got into an accident. He's saying that he needs compensation because this accident took place at the course of his employment. So the first person who is aggrieved, who is claiming to be aggrieved, is Vinayan, the employee. So the company is not ready to give. So the issue is related to the compensation. You identified the core issue. Right now, the issue is related to the compensation. Why compensation? Accident occurred. So why the compensation is given by the company? Because one saying is that it happened due to the course of his employment. The company is saying that he's not a young തൊഴിലാളി അല്ല, അതുകൊണ്ട് എന്തിനു കൊടുക്കണം? Okay, I identified one issue. You identified one issue. You jotted it down. Okay, so far, when I finished reading the first paragraph, I identified one issue, and that issue is that related to the compensation. So the core issue is that whether Vinayan is eligible for that compensation. And this delivery partner counts, can a delivery partner, this delivery partnership can be counted as a form of employment in the part of the company. So ഇത് ഫൈനൽ അല്ല, ഇത് നിങ്ങൾ ഐഡന്റിഫൈ ചെയ്ത, നിങ്ങൾ ഈ the course of your reading you identified this as an issue. ഇത് മാത്രമാണ് നിങ്ങൾ ഫസ്റ്റ് പാരഗ്രാഫിൽ ഐഡന്റിഫൈ ചെയ്യുന്നത്. Okay, okay, the problem is not finished yet. Let's read more. So this Mahesh Chandra Menon, a social activist, launched a public interest litigation addressing Vinayan's dilemma as well as concern raised in similar cases in the Supreme Court of India. So this one person who is an activist who filed a public interest litigation petition before the Honorable Supreme Court of India addressing Vinayan's dilemma. So what was Vinayan's dilemma? Can anyone please tell me what was Vinayan's dilemma? This public interest litigation addressed Vinayan's dilemma. What was, let me, this is to check you understood it properly, but what was Vinayan's dilemma? What was Vinayan's issue?
Whether he's an employee, yeah.
Or not. Yeah. And whether he is eligible for a compensation.
Okay, whether he's eligible for compensation, and yes, both of you are correct. Whether, yeah, whether he's eligible
he comes as an employee.
Okay, whether he can be, he's qualified.
Under the yeah.
Yes, yes. Okay, okay, right, true. So this guy, this person, this Mahesh Chandra Menon, a social activist, launched a public interest litigation addressing this person's Vinayan's dilemma as well as concerns raised in similar cases. Okay. And this petition was filed before the Honorable Supreme Court of India. Honorable Supreme Court of India under Article 32. So right now, when you finish reading the paragraph number 1, you identified an issue. Issue alone is identified. And the paragraph number 1 is not mentioning about anything other than the issue. Okay, such a thing happened. And this is what something which was happened in between two people, one a company and one a individual. No mentioning of the court. Nothing is there from the first paragraph regarding a case. A case is not being filed. Only an issue happened and a claim between two people. One a company, one a government-owned company, and another one a person. But the second paragraph is giving you an insight about the involvement of the court, how a court's concern reached, and public interest litigation was filed. Okay, now things are getting more serious. Things are getting clear, right? So here, after finding this case, the Supreme Court filed or framed certain issues. The first issue, whether the public interest litigation is maintainable. And second, whether a delivery partner is protected under the provisions related to the Code of Social Security 2020 for an unorganized workers. Third one, whether the right to social security is a fundamental right. So right now you have three issues. Right now you have three issues at hand. Three basic issues at hand. You have. And you are right now before the Supreme Court. Okay, please let me know who is the petitioner and who is the respondent. ആരാണ് വാദിഭാഗം ആരാണ് എതിർഭാഗം എന്നൊന്ന് ഐഡന്റിഫൈ ആകും. Who is the petitioner and who is the respondent?
Petitioner is the Vinayan and the other one is the victim.
Yeah,
Mahesh is petitioner.
Petitioner is Mahesh Chandra Menon.
Okay. So what was the nature of his petition?
It's a public interest litigation.
Yeah, public interest litigation. അപ്പോൾ നിങ്ങളുടെ ടീം ഫസ്റ്റ് വർക്ക് ചെയ്യാൻ തുടങ്ങുമ്പോൾ you wrote it down, you jotted down the facts that okay, this is a public interest litigation, and public interest litigation ആണ് മഹേഷ് ചന്ദ്ര മേനൻ എന്ന് പറയുന്ന ഒരു വ്യക്തിയാണ് ഈ പബ്ലിക് ഇൻട്രസ്റ്റ് ലിറ്റിഗേഷൻ ഫയൽ ചെയ്തത്. പബ്ലിക് ഇൻട്രസ്റ്റ് ലിറ്റിഗേഷൻ ഫയൽ ചെയ്യാനുള്ള കാര്യം എന്ന് പറയുന്നത് വിനയന്റെ ജീവിതത്തിൽ സംഭവിച്ച ഒരു അപകടമാണ്, അതേ തുടർന്നുണ്ടായ ഒരു കാര്യമാണ്. അദ്ദേഹം ഈ പബ്ലിക് ഇൻട്രസ്റ്റ് ലിറ്റിഗേഷനിൽ വിനയന്റെ ജീവിതവും മാത്രമല്ല ഇതുപോലുള്ള സിമിലർ ആയിട്ടുള്ള കാര്യങ്ങളെയും കോടതിയുടെ ശ്രദ്ധ ക്ഷണിക്കുവാൻ വേണ്ടിയിട്ട് ഇത് ഫയൽ ചെയ്തു. അപ്പോൾ once the court received and court framed the issues, first issue whether this bill is maintained, അപ്പോൾ ഇത്രയും എഴുതിയത് ഇത്രയും കാര്യങ്ങളെല്ലാം നിങ്ങൾ factual ആയിട്ട് you ascertain all these things in a factual matrix, like okay, now you identified a petitioner and then responding. The petitioner is Mahesh Chandra Menon. So right now you are dividing, if you can imagine a page, right now you are dividing between two, the whole page into two. One for the petitioner and one for the respondent. And for the petitioner, you're jotting it down. You have the scope of a bill because this is a public issue. And Mahesh and this Vinayan is injured. He's poor, not in a position to come to the court. So the public interest litigation petition is qualified. And also there are similar issues are going on in the line of pandemic. So this is seriously a public issue. It needs the concern of the court. You're writing all these points. And Vinayan is a delivery partner. Delivery partner means when it comes to a company which serves food online, the business, these delivery partners are considered to be the strong arms of these companies. Without delivery partners, they are not doing any business. Because Zomato പോലെയോ അല്ലെങ്കിൽ സ്വിഗ്ഗി പോലെയോ ഒരു കമ്പനിയുടെ നെടുന്തൂണെന്ന് പറയുന്നത് അവരുടെ ഡെലിവറി പാർട്ട്നേഴ്സ് ആണ്. അപ്പോൾ ഡെലിവറി പാർട്ട്നേഴ്സിനെ എംപ്ലോയീസ് എന്ന് വിളിച്ചില്ലെങ്കിൽ വേറെ ആരെയാണ് എംപ്ലോയീസ് എന്ന് വിളിക്കുന്നത്? ഇവരുടെ ആപ്പിലെ അൽഗോരിതംസ്. Can they call the algorithms of their app as employees? Are they doing the real job? Actually, these people who are doing the real job on the ground can be considered as an employee. So this Vinay is an employee. You're writing it down in the first part of the page where you wrote as petitioners. നിങ്ങൾ എഴുതി പോവുകയാണ് വിനയൻ എന്തായിരുന്നാലും ഒരു എംപ്ലോയി ആണ്. അതുകൊണ്ട് തന്നെ വിനയന് കോമ്പൻസേഷൻ കിട്ടണം. ഇത്രയും എഴുതിയപ്പോൾ when you reached to the portion called Vinayan deserves a compensation. Vinayan deserves a compensation. And when you reach this part, you reached into a dilemma. If I say so, whether the court will take it into consideration? No. The court will ask, what is the basis of your argument? My argument is that Vinayan deserves compensation. So the court might ask you back, what is the basis? So I need to do some research and I need to find a position of law which says that such forms of employment can also be considered as a full-time employee, and such kind of employees also deserve compensation or consideration. So you will conduct research. So you will look into all the labor law, all the employee code, the code of social security, everything. These are all social security measures. So you will conduct a good research and you identify legal points, because the argument you have made already. Your argument is that he deserves compensation. So to substantiate that argument, to make it solid, rock solid, you need legal points. So that is why you need to conduct a research. So there you conducted research, you read case laws, you identified enough and more points out there, and you made a list of decisions, judgment, everything you wrote under that part. Okay. So then you're moving on. Okay, that part is over. Vinayan deserves. This is a public interest litigation and it is maintainable. Because the most important point which is required for a public interest litigation is public interest, which is visible there. And you also researched you also read and identified certain case laws and marked it there. So right now, you identified the part that the delivery partner is also protected. That part is also identified. Then you need a brighter point. You need a much strong point. You filed a public interest litigation, and that even before a constitutional court, the Supreme Court of India. So the Constitution is the holy book. So we need something more from the Constitution. And also an issue is also framed. That is, the right to social security is a fundamental right. So fundamental right is the most important and the most strong point that you can raise. So if the social security benefits, if you are successful in proving before the court that all the social security benefits and all the social security, that is this right to social security, becomes part of the fundamental rights, then it is applicable to every citizen of this country. So Vinayan is also the citizen of this country. So Vinayans do get that right. So it is a fundamental right. So as a job provider, and moreover, this company is owned by government. And we know the fact that if any violation from the part of the government will come under the scope of fundamental rights. So this Good Food is a government company. And if you are successful in proving that right to social security is a fundamental right, then this company should give social security because it is a fundamental right. And moreover, it is a government company. So the next thing I need to prove, the right to social security is a fundamental right. This right to social security is a fundamental right. How will I prove it? I'll read. I'll read more. I'll read and read and read and read. So I read certain judgments which says that the social security is a fundamental right. I'll refer to foreign jurisdictions, I'll refer to case laws, the decisions of the Supreme Court, etc., etc. I'll identify that this is part of fundamental right, so that I'll make the arguments. So I'll fulfill, or I'll prepare an argument note for the petitioners to argue. Are we clear? Are you getting the point?
Yes, sir. Yes, sir.
Yeah. So at the very same time, the job is not at all ended. I mentioned to you, you have to prepare 2 sets of memorials. So right now you are in the zone of your brain is being orchestrated for the concern of the petitioners. Right now it is time to come back to the respondent side. So right now you want to work upon the respondent. So you are taking the second part of the page, which you are marked for the concerns of the respondents. എതിർഭാഗത്തിന് വേണ്ടി നിങ്ങൾ കരുതി വച്ചിരുന്ന ആ പേജിന്റെ മറ്റേ ഭാഗത്തിലോട്ട് നിങ്ങൾ വന്നു. അപ്പൊ എന്താ നിങ്ങൾ അവിടെ ചെയ്യാൻ പോകുന്നത്? What are you going to do? You people are going to frame arguments for the respondents. How will you do that? The first issue, let's focus on the first issue. The petitioners are saying that this public interest litigation is maintainable. So their core argument is that there is a public interest. There is an unavoidable stream of public interest. Now you need to prove, you need to disprove with it, and you need to prove that there is no scope of public interest litigation. This is a gimmick. How can you prove that it is not a public interest? Public interest is not involved in it. Yeah. So for that purpose, you will read judgments in which the court said that for public interest litigation, the court should be very much critical in before permitting a petition of that nature. You will take decisions of that sort. You will read so many number of decisions of the Supreme Court, in which Supreme Court wrote its decisions on public interest litigation. You might find some materials in which the court might have said that, okay, anything and everything is not a public interest. And this person, the course of employment, that means that it is the accidents. That means it should be that if an accident took place, the responsibility of the victim is also there. And he is on his own when he rides a bike. The company doesn't have any role. Company never contributed. So that you need to raise points. You need to first disprove with the fact that it is not a public interest is not at all involved. This is just a mere case of I'm not just right now I'm focusing upon the respondents. That is the reason why I'm using the terms like mere, minuscule, etc. This is a mere stunt to get it publicized. And this is just like another road accident which happens or which we see every day. When we drive, we will find someone who is streaming, who is racing in a bike with a big huge bag on their back, and the reason is that they are delivering food. They need to deliver it fastly. So we are seeing let's take the number of accidents which are happening, which are taking place right now. The accidents which are caused to these kind of delivery partners are very high in number. Why? Because they are mishandling the road. They're not handling, they're not riding their bikes well, not abided with the traffic rules, etc. So that the delivery, if such an accident happens due to the mistake of a rider or a delivery partner, how come a company be responsible? The company will be responsible. The company is providing them enough riding gears, enough directions, enough orders. So the rest is that the person who's riding the bike should be very much careful. So how can you say that the company is responsible? Company is responsible if an accident which took place, which do have a direct nexus to the company's role. Here it is not at all. The company is not a normal company. Company is a innovative company where the company is having a job to give the order to a particular partner, the delivery partner. And the rest of the job will be conducted by the delivery partner, and the delivery partner will also get a share. And this delivery partner cannot be equalized with the employer, because most of the social security benefits that a normal employer gets are absent in the case of this kind of delivery partners. So they will get a share of their profit. They'll get a share of the money which a company gets or the vendor gets from a client, from a person who's ordering the food. So this person's or this mode of employment cannot be regularized with the regular employment stream and the pattern that we are having. So in no way this person cannot be considered, or this kind of employment can be considered as a part of regular employment. So because of the same reason, yeah, I'll come back to you. Because of the same reason, this the social security benefits cannot be provided, compensation cannot be provided, and and like he never comes under the ambit of the social. And also you can add some points from you can develop some points from this. The road accident is something that happens in a road, right? That means one vehicle collided with another vehicle. So why he is not suing the other vehicle? Accident is something happening between two vehicles, or if he is like not riding in a proper way, and he's just crashing into a wall or crashing into like a tree or something like that. Even if that happens, there must be the role of some other person, right? Some other vehicle. Why in the facts of this case, nowhere in the facts of the case, no mention about the fact that how this accident was happened and what the role of another vehicle is not involved. Only this person is suing the company. That means that this accident is fully the fault of the employee, and for the fault of the employee, the company cannot be sued. So this point that you raised is that you identified from the facts of the case. And how can you develop all these points? By thinking, by roaming your mind around the facts of the problem. By that process, you can develop more and more and more. So you right now, for example, I'm not claiming it as valid points. I'm not claiming either it as invalid points. This is just an example. For example, you identified a problem, an argument like here, what I said. Here, this role of the employee is also there. No mentioning of another vehicle that caused the accident. The employee is hiding something here. That's the reason why he's alone suing the company. You raised it as an argument. How will you substantiate? If you raise it as an argument alone, the court will only consider, the court will only give a persuasive value. Court will only consider that, okay, the counsel is asserting something. The court doesn't have anything there which forces the court to consider it as a binding precedent. So to consider that, the court needs decisions. So how come you make this argument of yours? That means the person is hiding something, and it is only for the same reason that he is not mentioning any vehicle. So the argument is that it is his fault. It is his fault. So how can you make this as an argument? So you are searching, your mind is working. So right now you are researching for the fact that, okay, if any accident occurs from the part of an employee, if the accident is due to the mistake of the employee, then the employer is not responsible. You take that cue, you take that point. If the accident is causing due to the employee's mistake, then the employer is not liable. So you will identify decisions of the Supreme Court which is going on the same line. You will conduct research. You will conduct research, and you are identifying certain decisions which are saying that even due at the course of the employment, even at the course of the employment, if the employee is causing the accident due to his mere problem or his mere fault, then the employer cannot be blamed. You identified a decision or a judgment, you are quoting it. Now you are arguing before the court. Your Lordship, it is without doubt that say that according to the facts of this decision, here the Mr. Vinan is hiding something. Why? Because accident is something that happens in the road. When accident happens, two vehicles will collide or multiple vehicles will collide. So the role of another vehicle or another individual is very much mandatory. Then only we can call it as an accident. Or if the rider himself on sleeping or is lack of mind, he directly go and crashes to a tree or a wall or something like that. Even if there must be a reason. Here, without stating a reason, this person is claiming compensation from the employee. That means that the accident alone himself, it's his fault. So your lordship must look into a decision which is penned down by this court itself, which says that if the accident or any damage which is caused due to the mere inability or inadequacy of the employee, then the employer is not responsible. So, with the aid, in the light of that decision, this honorable court should consider the facts and the circumstances and give us a favorable verdict. So, you can make it as an argument. You can bring forth it as an argument. So, likewise, when you divide the whole problem into two, and you have to work for both the sides. When you find an argument for the petitioner, simultaneously, at the very same time, you need to think a point to counter the other side, counter this argument, and to find a point for the purpose of the other side. So likewise, you will formulate the arguments and you will prepare a good brief, a good written submission, and you will present it to the judges. Are we clear?
Yes, sir.
Yeah. So somebody raised hands the course of my explanation.
Yes,
Is that it? Yes.
Yeah, I have a doubt that now you said that that the employee doesn't come under. I mean, the Social Security Code does not give the gig worker, I mean, a delivery partner as a employee. But in the, I mean, in this code, it have clearly defined gig workers under unorganized, I mean, under unorganized sector. So gig worker comes as an employee under unorganized sector.
See, what I said is based on hypothetical assumptions, just to make you understand how to draft or how to work upon both the sides. I started explaining with a caveat that this is just hypothetical in nature. See, that
Yeah,
is
I understood.
yeah, and also
What I was having about.
yes. Without interjecting, let me add one more thing. And also, one more thing is that the Supreme Court issued notice last month in a case filed by all these workers of Zomato and collective workers form of all these kind of like online delivery, food delivery apps. Collectively, they filed a public interest litigation last month, and the Supreme Court issued notice, and the case is going on. And what their claim is that they want all the social security measures, and they need to be considered as a regular employee, equal to the traditional employment stream. The case is now ongoing on. So if we know the fact that these people are involved in the social security, then what is the scope of this problem? So what is ideal is that yes, we know the fact that there are certain mentionings in the labor code. Yes, we know that. But once you work, if this is a real case, if this is something happened as a see, what I'm not criticizing Hima, what she said is pointed out is correct. So that paved a way for me to explain. So I appreciate your concern, appreciate your question. That means that that is one of the fault that we might like consider. That means, okay, suppose in some occasions the problem that we are getting as a moot problem, we clearly know the fact that the law is something else and what the problem states is wrong, contrary to the existing law. We might be very much familiar, but no use. We need to prepare. We need to prepare. See, so for that reason, when you work for a moot problem, this moot problem, you might come across something contrary to the existing law. Even then, you need to work. That reveals your capacity as a counsel. So, and when you become an advocate, you will at times you will defend criminals, and you even very much sure about the fact that the criminals might have done this. So even then, you will defend them. Even then, you will defend them. What is the reason? Because that shows that shows your credibility. That shows your capacity as an advocate. That's what it is. Yes. So let's open the floor for the question and answer session. You can have questions.
So here the petitioner is Mahesh Chandra Menon. So when we are writing the memorial, can we when we are addressing the problem of Vinay, can we represent him as the petitioner, or can we represent him as a petitioner?
I got your question. You see, that is one thing that we need to be very careful about. Suppose here, see, in every mood problem, the students face this problem. Who can be considered as a petitioner and who can be considered as a respondent? Here it is very clear. That means at the end of the problem, it is very well stated that Mr. Mahesh Chandran Menon, who approached the court. So ideally, he's the petitioner. So what is the role of Mr. Vinayan? Vinayan is someone who is being aggrieved here. So Mahesh Chandra Menon is representing Vinayan's cause. Whether it is permitted, yes, at times it is permitted due to public interest litigation. So when you prepare the party array, you can prepare as Mahesh Chandra Menon versus the state of Kerala. You can prepare like this. Why? Because Mahesh Chandra Menon is the petitioner out here, and Mahesh Chandra Menon is suing who? That means the company called Good Food. Good Food is a government company, so state of Kerala and others. Because Good Food is not the only person. Because Mahesh Chandra Menon filed this public interest litigation as well as for Vinay's concerns as well as other concerns raised in similar cases. So he's also causing is also representing the causes of others. So there are chances for other parties also to get involved. So Mahesh Chandra Menon and others versus state of Kerala and others. That would be the ideal way to write. Understood?
Yes, sir. But when we are writing about the issue of Vinay, how can we represent him, or how can we write his name? Can we write his name as Vinay on the memorandum, or as petitioner or something else?
Could you please repeat the question?
So when we are writing the memo, we should write the issue of Vinay, right? So at that time, can we represent his name or as petitioner? Because we need to write.
When you write a memorial, the issues of the memorial should be in consonance with uh, what the court is saying. Let's take here. It is very clear. Let's look into the fact. What are the issues when you write the memorial? These are the issues. First issue is whether the public interest litigation is maintainable. So when you work on this public interest litigation, what is the scope of Vinay there? Public interest litigation is filed by Mahesh Chandra Menon. So Mahesh Chandra Menon is the petitioner. So Vinay's name is not material out there. So this basic question is whether this public interest litigation petition is maintainable. So we will work on that. We will work on the legal issue. What makes it not maintainable and what makes it maintainable. So it is a technical question. So let's go to the second issue. Whether a delivery partner is protected under the provisions related to the Code of Society. So once this public interest litigation, the court is holding it as maintainable, then the next question is that this whether whether a delivery partner, whether Vinayan, nowhere in the issue Vinayan's name is mentioned, whether a delivery partner is protected under the provisions related to the Code of Social Security 2021 for unorganized workers. So see, this is the question. So nowhere it is the name of the Vinayan is mentioned. It is the question of law is whether an unorganized worker or a delivery partner comes under the ambit of the code. That's the question. So that is a legal question need to be debated. Not Vinay's cause might ignite the whole issue. So the when you reach to a point where you need to mention the facts, there Vinay's name can be mentioned, not as a petitioner.
Okay, sir.
So
thank you.
Yeah, if Vinayan is represented by Mahesh Chandra Menon, then he can be because at times certain petitions are represented by next friend. This is not like that. This is a public interest litigation where you can mention the name of the Vinayan, but the petitioner is Mahesh Chandra Menon.
Okay, sir.
Yes.
Okay, sir. That's good.
Yeah. Please ask questions.
Sir, I have doubt in the rebuttal section. I mean, like, once after concluding, they ask for rebuttal. So, what we have to say in the rebuttal session?
So suppose, okay, are you finished with your question? Can I answer?
Yeah.
Yeah. So rebuttals is generally, see, look into the structure, how it is devised. First, the petitioner will speak. The petitioner will speak for, generally, the petitioner will get, during the preliminary rounds, every team will get 20 minutes, 20 to 30 minutes. So the petitioner, let's assume the petitioner spoke for 30 minutes. And afterwards, the respondent is speaking. So the respondent might have said something contrary or something that needs the clarification from the petitioners. So after the petitioner will speak and then the respondent will speak. Afterwards, if the petitioner needs to clarify certain things that emerged out of the arguments raised by the respondent, the petitioner, with the permission of the court, can avail a very few time. For example, 5 minutes. First, the petitioner will speak, and the respondent will speak, and then the petitioner can avail a 5 minutes or a 3 minutes time to clarify certain things or to defend certain things that are raised by the respondent. So in that time, petitioner cannot bring new arguments. During that time, the petitioner cannot bring or raise certain things that he didn't raise earlier. The petitioner can only counter or only clarify certain things that the respondent said. So also the respondent can also respond to rebuttals. The respondent can also, once the respondent finished his arguments, the petitioner will come and rebut. So after rebutting, if the respondent wants to say something, the respondent will equally ask for certain times that granted to the petitioner to counter what the petitioner said during the time of rebuttals. മനസ്സിലായോ? ആദ്യം പെറ്റീഷണർ വന്ന് ആർഗ്യുമെന്റ് പറയും, പിന്നെ റെസ്പോണ്ടന്റ് പറയും. റെസ്പോണ്ടന്റ് പറഞ്ഞതിൽ എന്തെങ്കിലും ഒരു വ്യത്യാസമോ വ്യതിയാനമോ അല്ലെങ്കിൽ എന്തെങ്കിലും ഒരു ക്ലാരിഫിക്കേഷനോ കൊടുക്കാനുണ്ടെങ്കിൽ കോടതിയുടെ സമ്മതപ്രകാരം കോടതിയോട് ചോദിച്ചിട്ട് ഒരു 5 മിനിറ്റ് ചോദിച്ചിട്ട് പെറ്റീഷണറിന് റിബട്ട് ചെയ്യാം. അപ്പോ അതൊരു അൺഡ്യൂ അഡ്വാൻറ്റേജ് ആവില്ലേ? അപ്പൊ അപ്പോൾ പെറ്റീഷണറിന് കൂടുതൽ സമയം കിട്ടിയില്ലേ, പെറ്റീഷണറിന്റെ സമയത്തോടൊപ്പം തന്നെ ഒരു 5 മിനിറ്റ് കൂടുതൽ കിട്ടിയില്ലേ, അപ്പോ അതിന് എന്തെങ്കിലും റെസ്പോണ്ടന്റിന് അതിന് എന്തെങ്കിലും മറുപടി പറയാനുണ്ടെങ്കിൽ റെസ്പോണ്ടന്റിനും ചോദിച്ചിട്ട് ഒരു പെറ്റീഷണർ കൊടുത്ത അതേ ടൈമിൽ റിബട്ടൽസിന് കൗണ്ടർ ചെയ്യാം. അതിന് പറയുന്ന പേരാണ് സർ റിബട്ടൽസ്.
സാർ എനിക്ക് ഇനി ഒരു ഡൗട്ട് ഉള്ളത്, ഞാനിപ്പം നമുക്ക് തന്ന 3 ഇഷ്യൂസ് ഉണ്ടല്ലേ, 3 ഇഷ്യൂസിന് നമ്മൾ ആർഗ്യുമെന്റ് റേസ് ചെയ്ത് റെസ്പോണ്ടന്റ് വന്ന് പറയുകയാണ് ഇത് മെയിൻറ്റൈനബിൾ അല്ല. സെക്കൻഡ് ഇഷ്യൂസിൽ അയാൾ സോഷ്യൽ സെക്യൂരിറ്റി കോഡിൽ വരുന്നില്ല എന്നും അയാൾ പറഞ്ഞു കഴിഞ്ഞു. തേർഡ് വൺ ഫണ്ടമെന്റൽ റൈറ്റിൽ ഉൾപ്പെടുത്താൻ പറ്റുന്നില്ല എന്ന് പറയും. ആഫ്റ്റർ ദാറ്റ് ഈ റെസ്പോണ്ടന്റ് വന്ന് ഇതിനെല്ലാം ആർഗ്യുമെന്റ്സ് തന്നതിന് ശേഷം ഞാൻ ഇപ്പൊ കൊടുക്കുന്ന ഐ മീൻ അതിന് കൊടുക്കുന്ന ഒരു ആർഗ്യുമെന്റോ ഇല്ല ഒപ്പീനിയൻ ആണോ റിബട്ടൽ എന്ന് പറയുന്നത്? the answers for that particular question.
യെസ്, ഇപ്പോ പറഞ്ഞ പോലെ ഇപ്പം ഹിമ വന്നിട്ട് പെറ്റീഷണർ ആണ്, പെറ്റീഷണർ പറഞ്ഞു. അപ്പോൾ റെസ്പോണ്ടന്റ് വന്നിട്ട് ഹിമ പെറ്റീഷണറാണ്, ഹിമ പറഞ്ഞതിന് എല്ലാം പെറ്റീഷണർ റെസ്പോണ്ടന്റ് വന്ന് എതിർത്ത് കുറെ കാര്യങ്ങൾ പറഞ്ഞു. അപ്പൊ ഹിമയ്ക്ക് തന്നെ അറിയാം ഈ റെസ്പോണ്ടന്റ് പറഞ്ഞ പല കാര്യങ്ങളും വസ്തുതാ വിരുദ്ധമാണ്. റെസ്പോണ്ടന്റ് പറഞ്ഞ് ഹിമ പറഞ്ഞു എന്ന് പറഞ്ഞ് റെസ്പോണ്ടന്റ് പറഞ്ഞു. ഫോർ എക്സാമ്പിൾ റെസ്പോണ്ടന്റ് എന്ന് പറയാണ് ഹിമ അത് പറഞ്ഞു, ഹിമ ഇത് പറഞ്ഞു, യു സെഡ് സംതിങ് ലൈക്ക് ദിസ്, യു സെഡ് സംതിങ് ലൈക്ക് ദാറ്റ്. റെസ്പോണ്ടന്റ് ആർഗ്യൂഡ് ലൈക്ക് ദാറ്റ്. So you know the fact that you didn't say such things, or you identified certain things that ഈ ചിലപ്പോൾ റെസ്പോണ്ടന്റ് വന്ന് കുറെ കണക്കുകൾ നിരത്തി. Respondent gave a statistical analysis. So you even know the fact that this statistics and this numbers and figures are wrong. So you need some time to get the attention of the court to dismantle their arguments. You need to clarify to the court that I never said such things, and the numbers or the figures or the arguments or the decisions, whatever the respondent raised, are faulty or wrong. So you need certain times to counter them. So that is അതിനാണ് നിങ്ങൾക്ക് ആ ഒരു ടൈം കിട്ടുന്നത് റിബട്ടൽസ് എന്നുള്ള രീതി. മനസ്സിലായോ?
Not the answers, എതിർ ഇതല്ല ഉദ്ദേശിക്കുന്നത്.
പുതിയതായിട്ടൊരു ആർഗ്യുമെന്റ് അവിടെ കൊണ്ടുവരാൻ സാധിക്കില്ല. ആ റെസ്പോണ്ടന്റ് പറയുന്നതിന് നിങ്ങൾക്ക് വേണമെങ്കിൽ ഒരു എതിർക്കാം, ക്ലാരിഫിക്കേഷൻസ് കൊണ്ടുവരാം, ഉത്തരങ്ങൾ നൽകാം. പക്ഷെ പുതിയൊരു ഈ പറഞ്ഞ 3 ഇഷ്യൂ അല്ലാതെ 4മതൊരു ഇഷ്യൂ കൊണ്ടുവരും, അത് പറ്റില്ല. ഈ 3 ഇഷ്യൂവിൽ നിങ്ങൾ പറഞ്ഞതിന് എതിരായി മറ്റേ ഭാഗം പറഞ്ഞത് അതിനെ നിങ്ങൾക്ക് എതിർക്കാം, അതിന് നിങ്ങൾക്ക് തിരിച്ചുത്തരം നൽകാം, അതിലെന്തെങ്കിലും തെറ്റുണ്ടെങ്കിൽ ചൂണ്ടിക്കാണിക്കാം. ഇതൊക്കെ എന്തിനാ ചെയ്യുന്നത്? to make your side stronger. You cannot bring a new argument out there. That is the difference.
ഒരു എക്സാമ്പിൾ ആയിട്ട് ഞാനൊരു കാര്യം ചോദിച്ചു. ഇപ്പൊ ഇതിന്റെ ഇപ്പം റെസ്പോണ്ടന്റ് വന്ന് പറയുകയാണ് ലൈക്ക് ഈവൻ ദോ ദി സോഷ്യൽ സെക്യൂരിറ്റി കോഡ് വന്നിട്ടുണ്ട്, ഇതിന്റെ ഗിഗ് വർക്കേഴ്സ് ഉൾപ്പെട്ടിട്ടുണ്ട്, ബട്ട് വി ഡോണ്ട് ഹാവ് എ ക്ലിയർ പിക്ചർ ഐഡിയ ഹൗ ടു കോമ്പൻസേറ്റ് ദം, ഒരു ആംബിഗ്വിറ്റി നിൽക്കുവാണ് എന്ന് പറഞ്ഞു കഴിയുമ്പോൾ I mean, they have argued their part. So, like, whether I can come and say anything for that particular argument?
Yeah, you can say. Very well say. Okay, വേണമെങ്കിൽ പറയാം. If you are a respondent, for example, if you are a petitioner, if the respondent is saying that even though yes, the code അങ്ങനെയുണ്ട്, പക്ഷെ അതിനൊരു ambiguity ഇല്ല, അതിന് ambiguity ഉണ്ട്, clarity ഇല്ല എന്നൊക്കെ റെസ്പോണ്ടന്റ് ആണ് വന്ന് പറയുന്നതെങ്കിൽ, as a petitioner, you can very well say that this is very unfortunate from the part of the state, because the state is the one who enacted this law. Now the state is saying that the very law they have enacted is unclear. So this needs to be struck down, or this needs to be clarified. എന്നുള്ള രീതിയിൽ നിങ്ങൾക്ക് തിരിച്ച് കൗണ്ടർ ചെയ്യാം.
So whether that should be done in the rebuttal section or immediately after the respondent's argument, I can come on.
See, rebuttal session എന്ന് പറയുന്നത് വളരെ കുറച്ച് സമയം നിങ്ങൾക്ക് കിട്ടത്തുള്ളൂ. ഹാർഡ്ലി ഒരു 5 minutes മാക്സിമം കിട്ടുക, മാക്സിമം 5 minutes. അപ്പൊ അതില് വളരെ കുറച്ച് സമയം കിട്ടുന്നത് തന്നെ യു കനോട്ട് ഗോ ഫോർ എ ഫുൾ ത്രോട്ടിൽ ഓർ എ ഫുൾ ലോങ് ആർഗ്യുമെന്റ്. യു കൻ ജസ്റ്റ് ക്ലാരിഫൈ സർട്ടൻ വെരി ഇമ്പോർട്ടന്റ് തിങ്സ്. പെറ്റീഷണർ വന്ന് ഇപ്പൊ ഇതിന്റെ കാര്യം പറയുമ്പോൾ പെറ്റീഷണർ ആർഗ്യൂ ചെയ്യുന്ന സമയത്ത് നിങ്ങൾക്ക് പെറ്റീഷണർ സൈഡിൽ ആർഗ്യൂ ചെയ്യുന്നതിന് മുമ്പ് റെസ്പോണ്ടന്റിന്റെ മെമ്മോറിയൽ നിങ്ങൾക്ക് കിട്ടും. അതായത് നിങ്ങളുടെ കോമ്പറ്റീഷൻ തുടങ്ങുന്നതിന് മുമ്പ് തലേ ദിവസമോ അല്ലെങ്കിൽ അന്നോ നിങ്ങൾ അവിടെ ഇരിക്കുന്ന സമയത്തോ അവരുടെ മെമ്മോറിയൽ നിങ്ങൾക്ക് കയ്യിൽ കിട്ടും. ആ സമയത്ത് you could go through the memorial and to learn what are the major arguments of the respondent. അപ്പൊ അതും വച്ചിട്ട് നിങ്ങൾ ആർഗ്യൂ ചെയ്യുന്ന സമയത്ത് when you argue as a petitioner in the first place, you can argue that my learned friend might raise this point, or my learned friend from the opposition may argue this, so I'm countering here. ആ സമയത്ത് നിങ്ങൾക്ക് വേണമെങ്കിൽ ആർഗ്യുമെന്റ് കൊണ്ടുവരാം, റിപ്പട്ടൽ സമയത്തും നിങ്ങൾക്ക് കൊണ്ടുവരാം. പക്ഷേ there is a time constraint. You will only hardly get 5 minutes or 3 minutes. Or in certain competitions, they won't permit you for rebuttals.
Sir, may I ask one question? So the second issue deals with the Code of Social Security. And in this real case, they have dealt with unorganized, like one act is there, 2008 Act. Should we deal about such acts like ESI, something other than Code of Social Security, or should we focus only on Code of Social Security?
No, there is no limitation. Whatever law which comes to your way as a savior, you can make use of it. Don't limit yourself with the Code of Social Security 2020. You can go through any and every law which seems relevant. I repeat, which seems relevant. If it is relevant, there is no constraint at all. You can make use of it.
Like, can we say that in that particular act, that is for unorganized workers, 2008, there's an act. It has been said that their claim is that these unorganized workers have to be protected. So, can we raise that issue?
Yeah, you can raise as a sub issue. You can raise it as a sub issue, because the major issue out here is second issue, and as a sub issue under the second issue, you can raise it as a sub issue. But before you raise, I again repeat, you need to prove it. First of all, you need to satisfy yourself that it is a relevant issue. Why I am saying so? Because Labor Code, Social Security Code is a compiled work which consists of so many legislations together. So if you're quoting another legislation, you need to check whether that legislation is existing right now, whether that legislation is expired, whether that legislation is unconstitutional, or the presiding legislation had already devalued the earlier legislation. So all these concerns should be taken care of. So that's why I said you need to be very careful in ascertaining whether that argument is relevant, or whether that material that you're trying to quote, material in the sense whether it can be a statute, whether it can be a legislation, whether it can be an order, rule, or whether it can be a precedent. But above all, when you place on table these materials, it should be relevant.
Okay, sir.
Any questions?
Sir.
Yeah, please.
സാർ പറഞ്ഞല്ലോ 3-4 സ്റ്റേജ് ആയിട്ടാണ് പ്രിലിമിനറി, ക്വാർട്ടർ, സെമി ഫൈനൽ, അങ്ങനെ ഒരു സ്റ്റേജ് ആയിട്ടായിരിക്കും ഈ മൂട്ട് നടക്കുകയെന്ന്. അപ്പോൾ നമുക്ക് തരുന്ന ഈ പ്രോബ്ലം ഈ എല്ലാ ലെവലിലും സെയിം തന്നെ ആയിരിക്കുമോ, അതോ ഓരോ സ്റ്റേജിലും അത് ഡിഫറെന്റ് ആയിരിക്കുമോ?
ഗുഡ് ക്വസ്റ്റ്യൻ. ഇത് സെയിം പ്രോബ്ലം ആണ്. ഇതൊരു കോമ്പറ്റീഷനിൽ നിങ്ങളെ ഇപ്പൊ 20 പേര് ഒരു കോമ്പറ്റീഷനിൽ പങ്കെടുക്കാൻ വരുന്നെങ്കിൽ 20 പേരെ നമുക്ക് ഫൈനലിൽ എത്തിക്കാൻ പറ്റും. അപ്പൊ ഇങ്ങനെ ഓരോ തട്ട് കമ്പാർട്ട്മെന്റ്, ഓരോ ലെവൽ ചെയ്ത് ഇങ്ങനെ നമ്മൾ ഓരോ ആൾക്കാരെ ഇങ്ങനെ ഏതൊരു മത്സരത്തെ പോലെയും ഇങ്ങനെ ഫിൽട്ടർ ചെയ്തെടുക്കുന്നതാണ്. അതിനുവേണ്ടി ആദ്യത്തെ റൗണ്ട് മുതൽ അവസാനത്തെ ഫൈനൽ വരെ ഒരൊറ്റ പ്രോബ്ലം ആയിരിക്കും. അപ്പൊ അതിനുവേണ്ടി ഇപ്പൊ പ്രിലിമിനറി റൗണ്ടിൽ 20 പേര് വന്നെന്ന് വെച്ചു. അപ്പൊ അതില് 1 മുതൽ 20 വരെയുള്ള ടീം, അപ്പൊ അവർ ഇങ്ങനെ ആയിരിക്കും ചിലപ്പോൾ ക്വാളിഫൈ ചെയ്യുന്നത്. പ്രിലിമിനറി റൗണ്ടിൽ നിന്നും നമുക്ക് 8 ടീംസിന് ഔട്ട് ഓഫ് 20 ടീംസ് 8 ടീംസിനെ സെലക്ട് ചെയ്യും. എന്തിലേക്ക്? ക്വാർട്ടറിലേക്ക്. അപ്പൊ അങ്ങനെ സെലക്ട് ചെയ്യുന്നതിന് വേണ്ടി ഓർക്ക് സെയിം പ്രോബ്ലം, അങ്ങനെ സെലക്ട് ചെയ്യുന്നതിന് വേണ്ടി 20 ടീമിനെ മത്സരിപ്പിക്കാൻ വേണ്ടി 10 കോർട്ട് റൂമുകൾ സെറ്റ് ചെയ്യും. ഈ 10 കോർട്ട് റൂമിൽ എങ്ങനെ അവർ നോക്കുന്നു വെച്ചാൽ ടീം 1 വേഴ്സസ് ടീം 11, ടീം 2 വേഴ്സസ് ടീം 12, ടീം 3 വേഴ്സസ്
ടീം 13. ഇങ്ങനെ ഈ 20 ടീമിനെയും പരസ്പരം ഇങ്ങനെ ഈ ഒരു പാറ്റേണിൽ അവരെ മത്സരിപ്പിക്കും. സെക്കൻഡ് റൗണ്ട് വരുമ്പോൾ അവർ ഇതിനെ റിവേഴ്സ് ചെയ്യും. ടീം 20 വേഴ്സസ് ടീം 2, ടീം 19 വേഴ്സസ് ടീം 3, അങ്ങനെ റിവേഴ്സ് ചെയ്ത് ഒരിക്കൽ മത്സരിച്ച രണ്ട് ടീമുകളെ ഒരിക്കലും വീണ്ടും ഒന്നുകൂടെ മത്സരിപ്പിക്കാതെ ഇങ്ങനെ റിവേഴ്സ് ചെയ്ത് 2 റൗണ്ടായിട്ട് വെച്ച് പ്രിലിമിനറി റൗണ്ടിൽ നിന്നും ഏറ്റവും കൂടുതൽ മാർക്ക് സ്കോർ ചെയ്യുന്ന, അല്ലെങ്കിൽ ഓരോരോ കോർട്ട് റൂമിൽ ജയിക്കുന്ന നമ്പർ ഓഫ് വിൻസിന്റെ കണക്ക് വെച്ചിട്ട്, അല്ലെങ്കിൽ ഏറ്റവും കൂടുതൽ മാർക്ക് അഗ്രിഗേറ്റ് സ്കോർ അനുസരിച്ചിട്ട് 20 ടീമുകളിൽ നിന്നും, ഇപ്പൊ ഞാൻ 20 എന്നൊരു സംഖ്യ എടുക്കുന്നേ ഉള്ളൂ, ചില കോമ്പറ്റീഷനിൽ 30 ആവാം, ചില കോമ്പറ്റീഷനിൽ 50 പേര് പാർട്ടിസിപ്പേറ്റ് ചെയ്യുന്നതായിരിക്കാം, ചിലപ്പോൾ സപ്പോസ് 20 സംഖ്യ എടുക്കുന്നേ ഉള്ളൂ. അതിൽ നിന്നും 8 ടീംസിനെ നമ്മൾ ക്വാർട്ടേഴ്സിലോട്ട് കൊണ്ടുവരും. ഈ ക്വാർട്ടർ ഫൈനലിലും മത്സരിക്കുമ്പോൾ അപ്പൊ ബാക്കിയുള്ള 20 ബാക്കിയുള്ള 12 ടീംസും ഔട്ടാവും. പക്ഷെ അവര് നാട്ടിൽ പോകണമെങ്കിൽ ഇപ്പോൾ കോമ്പറ്റീഷൻ ഇപ്പൊ തിരുവനന്തപുരത്ത് നിങ്ങൾ മത്സരിക്കാൻ വന്നെങ്കിൽ തിരിച്ച് നിങ്ങൾക്ക് എറണാകുളത്ത് വരണമെങ്കിൽ എറണാകുളത്ത് വരാം. പക്ഷെ നിങ്ങൾക്ക് അവസാനം വരെ അവിടെ നിൽക്കാം, കാരണം നിങ്ങൾക്ക് പാർട്ടിസിപ്പേഷൻ സർട്ടിഫിക്കറ്റ്സ് ഒക്കെ ഉണ്ടാവും. പല കോമ്പറ്റീഷൻസിലും ബെസ്റ്റ് സ്പീക്കർ എന്നൊരു അവാർഡ് ഉണ്ട്, എല്ലാ കോമ്പറ്റീഷനിലും ഉണ്ട്. ഈ ബെസ്റ്റ് സ്പീക്കർ അവാർഡ് കൊടുക്കുന്നത് പ്രിലിമിനറി റൗണ്ടിൽ വെച്ചിട്ടുള്ള പെർഫോമൻസ് വെച്ചിട്ടായിരിക്കും. ചിലപ്പോൾ നിങ്ങളുടെ ടീം ജയിച്ചില്ലെങ്കിൽ കൂടി നിങ്ങളുടെ പെർഫോമൻസ് ചിലപ്പോൾ നല്ലതായിരിക്കും. അപ്പൊ നിങ്ങൾക്ക് വേണമെങ്കിൽ ബെസ്റ്റ് സ്പീക്കർ അവാർഡ് ഒക്കെ ചിലപ്പോൾ കിട്ടിയെന്ന് വരാം. അപ്പൊ അതുകൊണ്ട് കോമ്പറ്റീഷൻ കണ്ടുപഠിച്ച് അവസാനം വേണം നിങ്ങൾ തിരിച്ചു വരാൻ. അപ്പോൾ സപ്പോസ് ഈ 20 ടീമിൽ 8 ടീമിനെ ക്വാർട്ടറിൽ എടുത്തു, ബാക്കി 12 ടീംസ് ഔട്ടായി. ഈ 8 ടീംസിൽ നിന്നും ക്വാർട്ടർ ഫൈനൽസ് നടത്തി 4 ടീംസിന് സെലക്ട് ചെയ്യും. 8ൽ നിന്ന് 4 പേര് ഔട്ടാണ്. എന്തിനു വേണ്ടിയിട്ട്? സെമി ഫൈനൽ. അപ്പോഴും സെയിം പ്രോബ്ലം ആയിരിക്കും, ഡിഫറെന്റ് ജഡ്ജസ് ആയിരിക്കും. ഈ 4 ടീമിൽ നിന്ന് ഇപ്പം 1, 2, 3, 4 എന്നുള്ളതാണെങ്കിൽ 1 വേഴ്സസ് 3, 2 വേഴ്സസ് 4, അല്ലെങ്കിൽ 1 വേഴ്സസ് 4, 2 വേഴ്സസ് 3 എന്നുള്ള എന്തെങ്കിലും ഒരു പാറ്റേൺ, ഒരു ലോജിക് വെച്ചിട്ട് മത്സരിപ്പിച്ചിട്ട് ഈ ക്വാർട്ടർ ഫൈനൽസ്, സെമി ഫൈനൽസിൽ നിന്നും 4 പേര് പങ്കെടുത്ത് 2 കോടതി മുറികളിൽ വെച്ച് നടന്ന ഈ ക്വാർട്ടർ ഫൈനൽസിൽ, സെമി ഫൈനൽസിൽ നിന്നും 2 ടീമിനെ ഫൈനലിലോട്ട് സെലക്ട് ചെയ്യും. സപ്പോസ് 1, 2, 3, 4 എന്ന് പറയുന്ന പാറ്റേണിൽ മത്സരിച്ച ടീമുകളിൽ 2ഉം 4ഉമാണ്, അല്ലെങ്കിൽ 2ഉം 1ഉമാണ് ജയിച്ചത് എന്ന് വെച്ചോളൂ. അപ്പൊ ഈ 2 പേരും ഫൈനലിൽ മത്സരിക്കും. സെയിം പ്രോബ്ലം, 1 വേഴ്സസ് 2. ഇതാണ് അതിന്റെ ഒരു പാറ്റേൺ. മനസ്സിലായോ?
യെസ് സർ, താങ്ക് യു. അപ്പോൾ സാർ നമ്മൾ ഇപ്പൊ ഈ ഡിഫറെന്റ് സ്റ്റേജസിൽ സെയിം പ്രോബ്ലം തന്നെ ആയിരിക്കുമ്പോൾ നമ്മൾ ആദ്യമേ കൊടുത്തിരിക്കുന്ന ചില പോയിന്റ്സ് ഒക്കെ അടുത്ത സ്റ്റേജിൽ നമുക്ക് പ്രീവിയസ് എക്സ്പീരിയൻസ് വെച്ചിട്ട് നമുക്ക് അമെൻഡ് ചെയ്ത് സബ്മിറ്റ് ചെയ്യാൻ പറ്റുമോ?
യെസ്, അത് നല്ലൊരു ചോദ്യമാണ്. ഇതിപ്പോ നിങ്ങളിപ്പോ ആദ്യത്തെ റൗണ്ട് നിങ്ങളത് മൂട്ടിൽ മത്സരിക്കാൻ പോകുമ്പോൾ യു വിൽ എക്സ്പീരിയൻസ് ദാറ്റ്. എന്തെന്ന് വെച്ച് കഴിഞ്ഞാൽ ആദ്യത്തെ റൗണ്ടിൽ 1ാമത്തെ സെഷൻ മത്സരിക്കുമ്പോൾ നമുക്ക് ഒരുപാട് ടെൻഷൻസ് ഉണ്ടായിരിക്കും. ഈ ടെൻഷൻസ് എന്ന് പറഞ്ഞു കഴിഞ്ഞാൽ നിങ്ങൾക്ക് അറിയില്ല, നിങ്ങൾ ഒരു ജഡ്ജിനെ ഫേസ് ചെയ്തിട്ടില്ല. ഒരു 2 റൗണ്ട് കഴിയുമ്പോഴേക്കും നിങ്ങൾക്ക് കോൺഫിഡൻസ് വന്നു തുടങ്ങും. അതിലൊരു ഗുണം എന്തെന്ന് വെച്ച് കഴിഞ്ഞാൽ 2 റൗണ്ടിൽ നിങ്ങൾ 2 ബെഞ്ചസ്, 2 ടൈപ്പ് ഓഫ് ജഡ്ജസിനെ അഭിമുഖീകരിച്ചിരിക്കും. 2 ടൈപ്പ് ഓഫ് ജഡ്ജസ് എന്ന് 1ാമത്തെ റൗണ്ടിൽ നിങ്ങൾ 3 പേര് ഒരു പാനൽ ഓഫ് ജഡ്ജസിനെ അഭിമുഖീകരിച്ചു. 2ാമത്തെ റൗണ്ടിൽ മറ്റൊരു പാനൽ ഓഫ് ജഡ്ജസിനെ അഭിമുഖീകരിച്ചു. അപ്പൊ ഇതിന്റെ ഒരു ഗുണം എന്ന് പറയുന്നത് നിങ്ങൾക്ക് എക്സ്പീരിയൻസ് കൂടാണ്. നിങ്ങൾക്ക് പ്രാക്ടീസ് സെഷൻസ്, ഒരു പ്രാക്ടീസ് പോലെയാണ്, എക്സ്പീരിയൻസ് കൂടുന്നു. മാത്രമല്ല ഒരേ പാനൽ ഓഫ് ജഡ്ജസ് അല്ല, 2 പാനൽ ഓഫ് ജഡ്ജസ് ആണ്. ഈ 2 പാനൽ ഓഫ് ജഡ്ജസ് ചോദിച്ച ചോദ്യങ്ങളെല്ലാം നിങ്ങൾക്ക് മനസ്സിലായി. അപ്പൊ അതിനർത്ഥം എന്ന് പറയുന്നത് നിങ്ങൾക്ക് മാക്സിമം നമ്പർ ഓഫ് ക്വസ്റ്റ്യൻസ് നിങ്ങൾ കേട്ടു, മാക്സിമം നമ്പർ ഓഫ് എക്സ്പീരിയൻസ് നിങ്ങൾക്ക് കിട്ടി. 3ാമത്തെ നിങ്ങൾ അത് കടന്ന് ക്വാർട്ടർ ഫൈനലിൽ എത്തുമ്പോൾ നിങ്ങൾക്ക് ഇത്രയും എക്സ്പീരിയൻസ്, ഇത്രയും ചോദ്യങ്ങൾ, ഇത്രയും ഉത്തരങ്ങൾ നിങ്ങളുടെ മനസ്സിലുണ്ട്. അത് വച്ചിട്ട് നിങ്ങൾക്ക് ഇവിടെ പെർഫോം ചെയ്യാം. അത് വേറൊരു ജഡ്ജസ് ആയിരിക്കാം. അത് നിങ്ങൾ കടന്നു കഴിഞ്ഞാൽ, ഒരു ക്വാർട്ടേഴ്സ് ഒക്കെ കടന്നു കഴിയുമ്പോൾ നിങ്ങൾക്ക് ഒരു കോൺഫിഡൻസ് ലെവൽ എന്നൊക്കെ പറയുന്നത് that will be skyrocketing. Like you will be in a mindset to face any kind of challenges. I remind you, semi-finals is one of the toughest, because semi-finals means finals will be in most of the national level competitions. Final round ജഡ്ജ് ചെയ്യാൻ വരുന്നത് റിയൽ ടൈം ജഡ്ജസ് ആയിരിക്കും. കേരളത്തിലോ എവിടെയായിരുന്നാലും ഹൈക്കോർട്ട് ജഡ്ജസ് ആയിരിക്കും. ഡൽഹിയിൽ വെച്ച് നടത്തുന്ന കോമ്പറ്റീഷൻസിൽ സുപ്രീം കോടതി ജഡ്ജസ് ജഡ്ജ് ചെയ്യാൻ പോകാറുണ്ട്. അപ്പോൾ കേരളത്തിൽ വെച്ച് നടത്തുന്ന മൂട്ട് കോമ്പറ്റീഷൻസിലെല്ലാം തന്നെ ജഡ്ജ് ചെയ്യാൻ വരുന്നത് റിയൽ ടൈം ഹൈക്കോർട്ട് ജഡ്ജസ് ആയിരിക്കും, ഒറിജിനൽ റിയൽ ടൈം സെർവിംഗ് ജഡ്ജസ്. സോ ഈ സെർവിംഗ് ജഡ്ജസിന് മുമ്പ് എത്തുമ്പോൾ quality should be maintained. So every സോ എവറി കോമ്പറ്റീഷൻ, എല്ലാ കോമ്പറ്റീഷനിലും ഈ ഒരു ക്വാളിറ്റി മെയിൻറ്റെയിൻ ചെയ്യുന്നതിന് വേണ്ടി ആ ഒരു സെമി ഫൈനൽ റൗണ്ടിൽ നല്ല കൈൻഡ് ഓഫ് ജഡ്ജസിനെ കൊണ്ടുവരും. ദാറ്റ് ഈസ് ലൈക്ക് പ്രാക്ടീസിംഗ് അഡ്വക്കേറ്റ്സ്, എക്സ്പീരിയൻസ്ഡ് അഡ്വക്കേറ്റ്സ്. ഈവൻ ഇപ്പോൾ എറണാകുളം ലോ കോളേജിൽ ഐ യൂസ് ടു ജഡ്ജ് ഫോർ എറണാകുളം national level competitions for the past couple of years. I even judged the semi-finals. So that is from, that doesn't mean that I'm good or something like that. So I am credentials പറയുന്നതല്ല. Fortunately, ഭാഗ്യം കൊണ്ട് എനിക്ക് ഒരു അവസരം കിട്ടി. അപ്പോൾ അതിന്റെ വെളിച്ചത്തിൽ പറയാണ്. So I got an opportunity. So I sat along with district judge, one district judge and one senior advocate. Senior in the sense, an advocate who is having experience in the Kerala High Court. I'm the least experienced one among that panel. So the questions from these people must be tougher. So once you gain this experience right from the grassroots level, participating in the in the preliminary rounds, so this will make you more confident. At least you could fight back. At least you could participate. So you can enter the Varghese ചോദ്യത്തിന് നിങ്ങൾക്ക് പൂർവ്വ റൗണ്ടുകളിൽ പങ്കെടുത്ത ആ ഒരു എക്സ്പീരിയൻസസ് നിങ്ങൾക്ക് യൂസ് ചെയ്യാൻ പറ്റും. ഡെഫിനറ്റ്ലി അതായിരിക്കും നിങ്ങളെ ഇവിടെ സേവ് ചെയ്യാൻ പോകുന്ന ഫ്യൂവൽ. That fuel will make you run miles. Got it? മനസ്സിലായോ?
Yes, sir. Thank you so much.
Yeah. ചോദ്യം ചോദിച്ചോളൂ. So once you finish your argument, you need to go on to the prayer. രണ്ടുപേർക്കും prayers ഉണ്ടാവും. So prayer, you have a format. I think you're familiar with the prayer. Prayer is something that you want. For example, if you are for the petitioner side, you might pray before the court that I implore before the honorable court to make this public interest litigation petition as maintainable and to hold this court as the delivery partner must be and is protected under the provisions related to Code of Social Security 2021. And I humbly pray before this court to held the right to Social Security as a fundamental right. That should be the prayer. But for the respondents, you will counter all this. The respondent might say, pray before the court that this bill is not maintainable and this delivery partner never comes under as an employee under this Social Security code, and this right to Social Security is not at all a fundamental right. So this will be the prayer. Prayer will be the one that you want to get from the court. What is the relief that you want to? So this is how you pray.
So one more question, please.
Yeah.
So if the labor ministry or the legislative body, if they have caught something related to this particular aspect, can we quote that in the memorandum?
I missed the first part. You mean the labor ministry?
Yeah, labor ministry or maybe the finance minister, like Nirmala Sitharaman, if they have pointed out some aspects of this particular thing in some budget or something like that, if labor minister have pointed out some aspects, can we quote that particular points in the memorandum?
Yeah, you can, but the value that it received is doubtful. You can quote it, but suppose please think this thing. Like a labor minister, as part of his parliamentary duty, as part of his parliamentary discussion, he mentioned a particular statement. And this has been recorded in a parliamentary proceedings record. And you're taking that record and bringing before the court of law, that is even the Supreme Court of India, and asking the court that the labor minister during his parliamentary session said so the court should also comply with it. Will the court comply with it? Is the court duty bound to respect or to follow or to bind that? Do you think so?
No, court will not follow.
No, sir.
Yeah, the court will not. The court is only lead it with its own decisions. That we call it as a precedent. That is why we are calling it as a binding precedent. So instead of quoting a statement made by a labor minister or a government document, you are bringing another judgment which was made by a constitutional bench of the Supreme Court. Then the court will consider it because it is a binding precedent. That is the difference. So since you mentioned it, since you brought it before the attention of the court might consider it as in a persuasive value, as a persuasive effect, not as a binding precedent for a material.
Yes.
Yes. Any questions?
ഹലോ സാർ.
യെസ്.
സാർ തന്ന പ്രോബ്ലത്തിൽ ഇഷ്യൂസ് സാർ തന്നെ ഫ്രെയിം ചെയ്തിട്ടുണ്ടായിരുന്നല്ലോ. അപ്പോ നമുക്ക് കിട്ടുന്നതിനകത്തും അതുപോലെ ഇഷ്യൂസ് ഫ്രെയിം ചെയ്തിട്ടുണ്ടാവുമോ അതോ നമ്മൾ ഇഷ്യൂസ് ഫ്രെയിം ചെയ്യണം?
ഒന്നാമതായി ഇത് ഞാൻ നിങ്ങളുടെ കോളേജിൽ നടക്കാൻ പോകുന്ന ഇൻട്രാ ലെവൽ മൂട്ട് കോമ്പറ്റീഷന്റെ പ്രോബ്ലം ആണ്. ഇത് ഞാൻ നിങ്ങളുടെ കോളേജിൽ നിന്ന് തന്ന ഒരു പ്രോബ്ലം ആണിത്. ഇത് ഞാൻ ഫ്രെയിം ചെയ്ത പ്രോബ്ലം അല്ല. പിന്നെ ഈ പ്രോബ്ലത്തിൽ ഇഷ്യൂസ് ഫ്രെയിം ഉണ്ടായി. ഇപ്പൊ വർഗീസ് ചോദിച്ച ചോദ്യം പിന്നെ ചില കോമ്പറ്റീഷനുകൾ, ഫോർ എക്സാമ്പിൾ സർട്ടൺ എല്ലാ കോമ്പറ്റീഷനിലും ഈ പ്രോബ്ലം ഇഷ്യൂ തന്നിരിക്കില്ല. It is the duty of the participants to identify the issues. എന്നെ സംബന്ധിച്ചിടത്തോളം, if I am drafting a problem, then I might do like that because അല്ലെങ്കിൽ ആ ഒരു വർക്ക് ചെയ്യുന്ന ആ ഒരു ആൾക്ക് ഒരു കപ്പാസിറ്റി വേണം ഇഷ്യൂസ് ഐഡന്റിഫൈ ചെയ്യാൻ വേണ്ടിയിട്ട്. അപ്പോൾ ചില കോമ്പറ്റീഷനുകളിൽ ഓൾറെഡി ഇഷ്യൂ തന്നിരിക്കും, ചില കോമ്പറ്റീഷനുകളിൽ ഇഷ്യൂ തന്നിരിക്കില്ല. സ്റ്റുഡൻസ് നീഡ് ടു ഐഡന്റിഫൈ. പക്ഷെ അങ്ങനെ ഇഷ്യൂ തരാത്തതിൽ നല്ലതുമുണ്ട് ചീത്തയുണ്ട്. നല്ലത് എന്താണെന്ന് ചോദിച്ചു കഴിഞ്ഞാൽ, വി ക്യാൻ ഐഡന്റിഫൈ പീപ്പിൾസ് കപ്പാസിറ്റി ടു ഐഡന്റിഫൈ ആൻ ഇഷ്യൂ. നമുക്ക് മനസ്സിലാക്കാൻ സാധിക്കും കുട്ടി അല്ലെങ്കിൽ ആ പാർട്ടിസിപ്പന്റ് എത്രത്തോളം ആ ഒരു പ്രോബ്ലം മനസ്സിലാക്കിയിട്ടുണ്ട്, എത്രത്തോളം അത് ഐഡന്റിഫൈ ചെയ്തിട്ടുണ്ട് എന്നുള്ളത്. ഇതിന്റെ ഒരു മോശവശം എന്തെന്ന് വെച്ച് കഴിഞ്ഞാൽ, നമുക്കൊരു യൂണിഫോമിറ്റി കാണിക്കും. ചിലപ്പോൾ ഒരു ടീം തെറ്റായിട്ടുള്ള ഇഷ്യൂ ആയിരിക്കും ഐഡന്റിഫൈ ചെയ്ത് കൊണ്ടുവരുന്നത്. അപ്പോൾ ഒരേ കോർട്ട് റൂമിൽ ഒരു ടീം വേറെ ഇഷ്യൂസും മറ്റൊരു ടീം വേറെ കുറെ ഇഷ്യൂസും ആയിരിക്കും. ഒരു യൂണിഫോമിറ്റി കാണിക്കും. അപ്പോൾ ഇതിന് ഒരു ചോദിച്ച ചോദ്യത്തിന് ഇല്ല, എല്ലാ കോമ്പറ്റീഷനുകളിലും ഇതുപോലെ ഇഷ്യൂസ് തന്നിരിക്കില്ല. ചില കോമ്പറ്റീഷൻസിലൊക്കെ ഇഷ്യൂസ് തരാതെ പ്രോബ്ലം മാത്രമായിരിക്കും. എന്നാൽ വേറെ ചില കോമ്പറ്റീഷനുകളിൽ ഇഷ്യൂ തന്നിരിക്കും.
താങ്ക് യു സർ.
ഓക്കെ.
One more doubt is there, like in the argument section, we can whether we can ask for the court to do something, like when there is an ambiguity in the court, whether we can ask the court to do some judicial, to issue an order to the state or to make certain rules, like as in the case of Visaka, they have given some provision for sexual harassment. Similarly, some rules can be issued. അങ്ങനെ എന്തെങ്കിലും പറയാൻ പറ്റുമോ? കോടതിയോട് whether we can
റിയൽ കോർട്ടിലാണെങ്കിൽ ഇതിന് സ്കോപ്പ് ഉണ്ട്. You have a scope, but we are doing right now, we are doing a mock court exercise. So as a constructive effect, നമ്മളൊരു കൺസ്ട്രക്റ്റീവ് ആയിട്ട് നമ്മൾ കുറച്ചുകൂടെ ഇന്നോവേറ്റീവ് ഒക്കെ ആയിട്ട് at the prayer നിങ്ങൾക്ക് ഈ പറഞ്ഞ ഇഷ്യൂസ് അല്ലാതെ you can ask for more relief from the court. That is possible. But when you do that, you should be very careful. It is a thin line. It's a slippery slope. Before asking such a relief, you should be very careful about the relevance of that relief. ആ ചോദിക്കുന്ന റിലീഫിന് ഒരു റെലവൻസ് വേണം. ഈ നോർമലി നമ്മളൊരു മൂട്ട് കോർട്ടിൽ തന്നിരിക്കുന്ന ഇഷ്യൂസ് അല്ലെങ്കിൽ അതിന് പ്രധാനപ്പെട്ട ഇഷ്യൂസിലായിരിക്കും ആ ഇഷ്യൂസിനെ സംബന്ധിച്ചിടത്തോളം ഒരു പോസിബിൾ ആയിട്ടൊരു റിലീഫ് കൂടെ കാണും. അതായിരിക്കും പോകുന്നത്. പിന്നെ ഈ ചോദിച്ചതുപോലുള്ള ഈ ഇന്ററിം റിലീഫുകൾ For example, High Court, Supreme Court, there are interim reliefs. ഇടക്കാല ആശ്വാസം. For example, റിപ്പോർട്ട് ചോദിക്കുക, അതുപോലുള്ള ഇന്ററിം റിലീഫ്സ് ഒക്കെ ഈ ഹൈക്കോടതികളിലും സുപ്രീം കോടതികളിലും ഉണ്ട്. പക്ഷേ മൂട്ട് കോർട്ടിന്റെ സ്കോപ്പിലോട്ട് അത് കൊണ്ടുവന്നു കഴിഞ്ഞാൽ നമുക്ക് ഇറ്റ് വോണ്ട് വർക്ക്. അതുകൊണ്ട് തന്നെ എല്ലാ പ്രോബ്ലത്തിലും, ഈ പ്രോബ്ലത്തിൽ അതില്ല, പക്ഷെ നിങ്ങളുടെ റിയൽ ടൈം പ്രോബ്ലത്തിലും റിയൽ ടൈം കോമ്പറ്റീഷന് പോകുന്ന എല്ലാ പ്രോബ്ലത്തിലും ഒരു വാചകം ഏറ്റവും അവസാനം കാണും. The court considered this issue for final hearing എന്ന് കണ്ടിരിക്കും. എല്ലാ മൂട്ട് കോർട്ട് പ്രോബ്ലത്തിലും ഇങ്ങനെ ഒരു വാചകം ഉണ്ടായിരിക്കും. The court holded this issue. For example, ഇതിൽ അങ്ങനെ ഇതുണ്ടെങ്കിൽ for final drafted the Supreme Court of India framed the following issues and held and posted for final hearing എന്നുണ്ടായിരിക്കും. അപ്പൊ അങ്ങനെ ഫൈനൽ ഹിയറിംഗ് ഉണ്ടായിരിക്കുമ്പോൾ ഇടക്കാല ആശ്വാസങ്ങൾ ഒരു ഫൈനൽ ആയിട്ടുള്ള ഹിയറിംഗ് ആയിരിക്കും അവരവിടെ നോക്കുന്നത്. അതുകൊണ്ട് തന്നെ ഈ പറയുന്ന പോലത്തുള്ള ഇന്ററിം മെഷേഴ്സ് എന്നുള്ള സ്കോപ്പ് കുറവായിരിക്കും. സോ ഇതെന്തിനാണ് നമ്മൾ അങ്ങനെ കൊടുക്കുന്നത്? കാരണം ഇതൊരു സ്റ്റുഡൻസിന് വേണ്ടിയിട്ടുള്ള ഒരു കോമ്പറ്റീഷൻ ആയതുകൊണ്ട് തന്നെ വി നീഡ് ടു ബി സർട്ടൺ അബൌട്ട് ദിസ്. സോ അതിന് വേണ്ടിയിട്ടാണ് അങ്ങനെ കൊടുത്തിരിക്കുന്നത്. ബട്ട് ഈ റിലീഫ്സ് ചോദിക്കുന്നത് വേണമെങ്കിൽ റിലീഫ്സ് ചോദിക്കുന്നത് വേണമെങ്കിൽ യു കെൻ ആഡ് ഓൾ ദീസ് റിലീഫ്സ് ആസ് എ കൺസ്ട്രക്റ്റീവ് മെഷർ ഇൻ ദ പ്രയർ. That you can do, but you should be very careful and thorough for all these reliefs that you are asking.
There is question that the social security cost 2020
You're not completely audible. You're not completely audible. I'm not hearing you properly.
ഇതിനകത്ത് നമ്മുടെ ഈ പ്രോബ്ലം ക്വസ്റ്റ്യൻ്റെ അകത്ത് they have asked under social security cost 2020 എന്നല്ലേ. ഞാൻ കോഡ് വായിച്ചപ്പം ഇത് എനാക്ട് ചെയ്തിട്ടുണ്ട്, കമൻസ് ചെയ്തെന്ന് പറയുന്നില്ല. അപ്പം
നോർമൽ പാർലൻസില് ഒരു മൂട്ട് കോർട്ട് പ്രോബ്ലത്തിൽ ഹൈപ്പോത്തറ്റിക്കൽ ലോ ആയിരിക്കും തന്നിരിക്കുക. സോ ഹൈപ്പോത്തറ്റിക്കൽ ലോ ആയിരിക്കും നമുക്ക് തരിക, അതായത് സാങ്കല്പികമായിട്ടുള്ള നിയമം. ഇപ്പൊ ഇന്ത്യ എന്ന് പറയുന്ന രാജ്യത്തിന് പകരം ഇന്ത്യാന എന്നായിരിക്കും, അല്ലെങ്കിൽ നമ്മുടെ രാജ്യത്തിന്റെ അതേ ഫീച്ചേഴ്സ് ഉള്ള വേറെ ഏതെങ്കിലും പേര് ഉണ്ടായിരിക്കും, ന്യായസ്ഥാനമോ രാജസ്ഥാൻ എന്തെങ്കിലും ഒരു പേര് അവർ കൊടുത്തിരിക്കും. എന്നിട്ട് അവസാനം ഓൾ ദ ലോസ് ഇൻ ദിസ് പ്രോബ്ലം ആർ ഇൻ പാരി മെറ്റീരിയ വിത്ത് ഇന്ത്യൻ ലോസ്, അതായത് ഇന്ത്യയിലെ നിയമങ്ങളുമായിട്ട് നമുക്ക് വേണമെങ്കിൽ ഇതിനെ താരതമ്യപ്പെടുത്തി കാണാമെന്ന് പറഞ്ഞിരിക്കും. അപ്പൊ ചില നിയമങ്ങളെല്ലാം തന്നെ അവിടെ അത് ഓൾറെഡി ഈ നമ്മുടെ നിലവിലില്ലാത്ത അല്ലെങ്കിൽ ഇനിയും ഇനാക്ട് ചെയ്യേണ്ട നിയമങ്ങളെ കുറിച്ച് മെൻഷനിങ് ഉണ്ടായിരിക്കും. പക്ഷെ അതെല്ലാം തന്നെ അതിൽ ക്ലാരിഫിക്കേഷൻ കാണും. യു ഡോണ്ട് നീഡ് ടു കൺസിഡർ ഇറ്റ് ആസ് യെറ്റ് ടു ഇനാക്ട്, കൺസിഡർ ഇറ്റ് ആസ് ഇനാക്റ്റഡ് എന്നുള്ള ക്ലാരിഫിക്കേഷനും അവിടെ ഉണ്ടായിരിക്കും. ഇതൊരു സാങ്കല്പിക കേസാണല്ലോ, അതുകൊണ്ടായിരിക്കാം അങ്ങനെ കൊടുത്തിരിക്കുന്നത്. പ്രോബ്ലത്തിലെല്ലാം
ഇതാണെന്നാണ് ധരിക്കേണ്ടത്.
അങ്ങനെയുള്ള സിറ്റുവേഷൻസിൽ വരുമ്പോൾ യു ഷുഡ് ആസ്ക് ക്ലാരിഫിക്കേഷൻസ് ടു ദ ഹോസ്റ്റ്. ദാറ്റ് ഈസ് വെൻ ഞാൻ മൂട്ടിന്റെ ആംഗിളിലാണ് പറയുന്നത്. When this kind of questions arise, you need to ask for clarifications. And it is an actual practice that for national level competition, a deadline will be given to you. That is, you can ask clarifications until this date. They will collectively answer to your questions. So I'm not going to comment on this problem because this problem is a hypothetical problem. It is a sankalpika problem മാത്രമാണ്. This is not a real time problem. Yes. Questions, please. Any questions?
Sir, I hope there aren't any more questions.
Okay. That note, thank you so much for giving me an opportunity, and thank you so much for interacting and showing your enthusiasm. And again, take this opportunity to thank Dr. K.R. Raghunathan sir and Vilovan, Ashwati ma'am, and every member of the college, students, Alka, and for organizing this effectively. And thank you all, and all the very best for everyone for the intra-level competition as well as for the voting endeavors that you will take up in future. Thank you so much, and all the best. Have a great evening to one and all.
Thank you so much, sir, for your time and this valuable session. And I hope all of the students who attended this session was beneficial to all of them, which is very evident from the open discussion that we had a few minutes before. So to wind up, I invite Julia to deliver the vote of thanks.
A warm and graceful evening to our most valued honorable guests, our principal sir, teachers, coordinators, and all the participants. It's my privilege to propose a vote of thanks on this occasion. I wish all of you in the best of your spirits. On behalf of Sri Narayana Law College, I extend a most sincere thanks to our chief guest, Advocate Vishwajit Anand, who spared time from his busiest schedule to grace the occasion. Thank you, sir. Thank you so much for your inspiring talk, and it was really informative and useful for us all. And I'm really sure that this will encourage us in our future. Thank you, sir. Thank you so much. Next, I would like to thank our beloved principal, Professor Dr. Raghunathan sir, for his continuing support. And I'm immensely thankful for our faculty coordinator, Babu Petavan sir and Ashwati ma'am for taking up this initiative. And I extend my grateful thanks to our student coordinator, Alka Warrior, for her great and measureless efforts. Last but not the least, I extend my gratitude and to all of you who were throughout the session. Without you, this session would not be a success. It has been a really great pleasure. Once again, I'm thanking you all. Thank you so much.
Thank you, Julia. Thank you so much, sir, for your time.
Thank you. My pleasure. Thank you so much.
Thank you, sir.
Thank you so much. Thank you.
Thank
one
you
and
so
all.
much, sir.
Thank you so much, sir.
Thank you. Thank you.